All right, I will call this meeting of the Senate Judiciary to order. Will the secretary please take the roll?
Senator Harris. Senator Orenthal. Senator Dondero Loop. Senator Wynn. Senator Hansen. Senator Krasner. Senator Stone. Chair Scheibel.
Please mark Senator Dondero Loop present when she gets back. We have 3 bills on for hearing today, as well as 13 bills on our work session this afternoon. It is that time of year where all of our presenters and all of our members also have other places to present and do work sessions and things like that, so we're going to have to be a little bit fluid today. I understand that I do have everybody here who needs to be here in order to present SB 413. So I'm going to start with SB 413. We'll do the hearing on that and then take it from there. So I'm opening the hearing officially.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. My name is Dallas Harris. I represent Senate District 11. Thank you so much for taking the time to hear Senate Bill 413 today. Just a quick little bit about the nexus and origination of this bill. During the Interim Judiciary Committee, we heard quite a bit of testimony around sentencing credits and the current system. I did a lot of research with my colleague, Assemblyman P.K. O'Neill, and one of the things that became very clear is that nobody understands how these sentence credits work. Family members have no idea when their incarcerated family members are going to get out. People who are incarcerated are constantly confused about why they earned a credit or didn't earn a credit and whether it's supposed to move their date up or back or exactly how it works. And so often they're submitting these kind of appeals because they think their credits are calculated wrong, but NDOC never makes a mistake, so they're always usually calculated correctly. But the people just don't understand. I have 4 degrees, and when I saw the worksheet on how sentencing credits are calculated, I have to admit I did not understand it. And I can't even tell you if I really do today, although I've gotten pretty close after months and months of studying it. The committee should have, as an example, available to them of what the current credit history system looks like. Take a quick glance and you will very quickly be able to see why this system needs substantial reform. And so, of course, I teamed up with the smartest person in this area, and that's the woman sitting next to my left, Miss Victoria Gonzalez, and she immediately put her brain to work along with the Department of Corrections, and we'll have him introduce himself very shortly, but he's also mostly here to answer questions, not to necessarily support or oppose the bill. And she began to do a lot of diligent science and data-based analysis on what the best way was to make this system more transparent for everyone. Victims, people who are incarcerated, and the families on both sides, as well as for the Department of Corrections, as I'm hoping you'll hear. Chair Scheibel, I don't see we have the presentation up on the screen. Is there some way we could maybe get that going?
We will work on that, yes.
Thank you. In the meantime, I'll turn it over to our friend from the Department of Corrections to introduce himself, to buy a little bit of time, because Ms. Gonzalez is going to, I'm sorry, go through a PowerPoint, but it'll be worth it and helpful and useful. I promise, otherwise we wouldn't have brought it to the committee. But it's important that you all are able to kind of see that, and the folks in the room are able to see it. But you should also have a copy of the PowerPoint with you at your desk if we do in fact have to not go with the visual up on the screen.
Thank you, Senator. Chair, to you, to the committee, my name is Kirk Widmar, W-I-D-M-A-R, and I'm the Chief of the Offender Management Division for the Department of Corrections. My division oversees sentence management and sentence calculation for the department.
Thank you so much, and that introduction was just long enough for us to figure out that we had to turn the TV on. Ms. Gonzalez, if you would, please.
Thank you, Senator, and thank you, members of the committee. We're really excited to be here and continue to work with you towards trying to figure out what does it look like to develop data-driven recommendations for our criminal justice system. So we first want to show you what's happening now. So as the Senator mentioned, you have an actual credit calculation sheet that could be provided to any incarcerated person upon request. This is how credits are being calculated right now. What I wanted to explain is that, oh, very good. Okay, all right.
It is also on Nellis.
Okay, perfect. And so one thing I want to explain first is when someone is sentenced, they are sentenced to a minimum and a maximum sentence. It's your minimum sentence that determines your eligibility for parole. And so generally, everyone's going to have credits calculated against their max, of course, that would determine when they're actually done serving their full sentence. It's the minimum sentence that can get a little complicated because certain individuals, specifically those who are categorized as felonies in C, D, or E, that are generally drug or property offenses, can earn credits off of their minimum. And so those individuals are earning credits off their minimum and their maximum. And so this is where our already very complicated credit scheme gets even more complicated when we're trying to figure out when are these individuals eligible for parole. And so as I have listed here, and as Senator mentioned too, as you look at this credit scheme and this credit calculation, some of the questions we just brainstormed you have first right off is which ones did I actually earn? Those credits that you see at the bottom are blue, those are projected. And I'm going to explain a little bit how that works. You might be wondering how many credits were not earned. When is this person actually eligible for parole? And you may think, what does that credit mean? And then another question people have all the time is like, so the dates keep moving? Along with when is the offender eligible for parole, when is an incarcerated person eligible for parole, when a judge hands down their sentence, what does the sentence actually look like? So we created a visual here. So let's imagine, again, for that individual who is looking towards parole eligibility, where their credits would be taken off of their minimum sentence. Month one, they show up, they would have a projection. The way it works right now is the good time credits and the work credits are projected to determine a parole eligibility date as a starting point. After someone serves their first month, then the actual good time credit they earned is applied, in addition to additional projected good time credit that could be earned. And then whether or not the person actually worked, as you can see in the credit sheet, that's actually deducted. So that gets confusing. How did I lose credits? Well, I just didn't earn them according to the projection. And then the additional projected credits are added again to try and determine the parole eligibility date. And so you can see from month to month, it can change just like this. That parole eligibility date can move further out. Of course, there's opportunities to earn additional education. So you can see in month 5, let's pretend that this person earned their GED. They would get additional credits. How does that factor into then the projections? And you can see the parole eligibility date could move back a little bit. But then let's say again, someone couldn't work based on what was projected that they could work. And then there was a disciplinary issue. And so again, these dates are moving with all of these factors at play. And there's other credits that could be earned. This is, believe it or not, a simplified version of what the credit scheme looks like right now. And as I will note, this is not to scale on dates. So don't try and identify the specific dates that are earned. So as the Senator mentioned, this is a problem. And the problem we see is that this impacts everyone, district attorneys, victims, judges, the incarcerated person. When is this person eligible for parole? When are they likely to be released to supervision? So we realized the problem and started some research. What we discovered is that some states, instead of having a credit scheme as complicated as ours, and I will say we're one of the most, if not the most complicated credit scheme in our part of the country. And so when we researched other areas, some states use a percentage. They use a percentage to determine parole eligibility. And that percentage then is considered part of when your sentence is handed down. It's directed to everyone that at this percentage, as long as you're on good behavior, we anticipate you can be released to parole. So taking that framework in mind, we thought, then what does our credit scheme look like right now if we were to convert everything to percentages? So here's the methodology that we used. We analyzed releases from 2017 to 2022. We focused only on new commitments, so this data set does not include anybody who came back from parole and then went back out on parole, anyone who had to serve any sort of revocation time. This data set only includes one offense in the booking, so any of those individuals who have multiple sentences that are being served either concurrently or consecutively are not included here. We started their sentence start date includes the retro date, which means jail credits that they might have been applied while they were waiting for their outcome to their sentence is part of this determination. And then what we did is we divided the time served before release to parole by their minimum sentence to get to the percentage. I will say, too, we did a study across all offense groups and all felony categories. The data I'm about to show you is just on those C's, D's, and E's in the drug and property offense, because those are the individuals who are getting credit off their minimums, and that's the most complicated part of this. But just so you know, we have data for all of these offense groups and all of these felony categories. So when it comes to how do we now analyze the data that we have? We started with a typical average that we think of. So that's where we added up all the possible percentages that someone had in each of these felony categories and then divided it by the number of instances that we had in that data set. So you can see here that for the C's in the drug and property offense group, it's 71%, the D's are 72%, and the E's are 75%. We went across, and it's difficult to figure out how do you decide where to start. So then we did next, which you'll see on the next slide, is we took all of those occurrences together and then added up every single average and then divided it by the total and then came up with the 75% as a starting point. But I wanted to show you what happens when we're trying to analyze the data. What I want to educate the committee about as we really engage in data-driven policies is a phrase that we use in data analysis called slice and dice, is what we refer to it as. So when you have a data set, there's so many things you can do to slice and dice the data. Are we looking at averages? Are we looking at occurrences? Are we looking at what's the most common? And one of the things that I've noticed has been lacking with previous data presentations is you only get one slice and one dice. You don't get the full picture. And so what we realized, in order for you to make a truly data-driven decision, is you have to see all the versions of the slicing and dicing that could be done. So on this slide is where you can see we combined all the C's, D's, and E's together with drug and property and looked at what percentage they served. So with the numbers on each top of the bar, the number of individuals who served that percentage. And then across the bottom, you can see the percentage that we're showing that they served. I will note that this visual only includes most occurrences. We did not include every single occurrence. There is a few below and a few above this data set, but for ease of looking at this visual, wanted to just cut out where did the most occur. So I can tell you there are, and I'll give you more detail on the next slide about who's in this data set. So what we can see here is when we break it down, who actually makes up that 75% after we've combined everybody, right? And so we can see that there's not one percentage. There's not one percentage that everybody's getting because of our complicated credit scheme. And we can see what a percentage actually looks like when you have an average, what these percentages look like with an average. And that's where I would recommend when we are presented with data, we need to ask a lot of questions about, well, what does that average actually look like, right? What does it mean when we think this is what the most common data point is? And I just wanted to point that out as far as when you're making data-driven decisions in the future, make sure we consider all the slicing and dicing that's been done to get the data before you. So a couple of details I wanted to point out about what I just presented on the previous slide, that represents 1,712 of the category C, D, and E felonies in the drug and property offense, and that of those individuals, they served 47% to 105% of their minimum sentence upon release to parole, and then of those, we found that 54% served 65% or less of the minimum before being released to parole, and so that's 920 of the 1,712. And there was 1,841 in the initial data set. So that'll be all the numbers I read, but I can come back to those. So once we now slice it differently, this is what it looks like. So if we now slice in the middle, where is the most common? It's actually just below 65%. Because what you have before you today is an amendment to adjust the percentage from awarding 25% to 35%. And I think this is a good starting point to show you this is what it looks like to be data-driven. Which average do you want to use? Which part of the occurrences do you want to use? We don't have one common occurrence here, but in order for you to make this fix to the credit system, which needs to be done, we have to start somewhere. And this is the data we have to get you started. So with the visual, when we think about what that other visual looked like, if whatever the percentage is that's allotted to the person who's incarcerated, this is what it would look like. We have transparency in what we can expect in the sentence. So we're going to have the projected percentage, whatever that may be, and in the amendment for this would be the 35%. You have a parole eligibility date, month 1. Month 2, it's the same. The individual is doing everything they're supposed to do with their case plan. They've been on good behavior, and so they're still where that parole eligibility date has not changed. The only thing under this proposed scheme that would change the eligibility date would be if there was a disciplinary issue, which is already available in statute or in regulation. So the Department of Corrections already has a regulatory scheme for dealing with disciplinary issues. And so now this good time credit, so to speak, or this credit that you get for doing what you're supposed to be doing while you're incarcerated is set. It's not going to change. This proposal wipes out all the existing credits and provides just this percentage. And the only thing that could change this date now would be disciplinary issues. And it's going to be very clear because we're not trying to compete with a projection like we were in that other scheme, where you're trying to figure out how do these number of dates now affect the projected date. It's just straight, here's this percentage. Disciplinary issue took off this many dates, and the Department of Corrections is very clear on the number of days based on the type of violation, how that would impact you. And so it's very clear the consequence. You can very clearly see your carrot and your stick when it comes to what is, how are we motivating and how are we determining success or not success for incarceration. I do have data for those who are serving their maximum. The maximum sentence, you can see it does, I think if we slice it and dice it in the same way where we look at where the majority is, we're looking at around that 65% or lower. This combines also those who had been released to parole and then came back because they earn credits while they're on parole as well. So the percentage proposed here would be consistent with what they would earn in DOC, but it is possible for them to earn more while they're on parole. The last thing I just wanted to say is that the intent of this bill is to codify what's already happening. Again, I've said this before for this committee. My agency and what I do is nonpartisan. We do not have a policy agenda. What we want is to ensure that you can make data-driven recommendations and have data-driven policy in our criminal justice system. This would codify what's already happening. Our intent is to keep the status quo so that we can promote transparency for everybody with sentences, and you'll know exactly what to expect. This current scheme, I'm telling you, is untenable. I think we are at a breaking point, or that breaking point is coming soon if more credits were added, if credits were adjusted, and it's not clear to anybody what's happening. As we're moving towards truly data-driven criminal justice, a truly data-driven criminal justice system, you now have this opportunity to make this change for you and future legislative sessions and legislators to be in the right place to make the adjustments that can be data-driven and clear and transparent to everyone.
And Madam Chair, if I may, I just want to make a couple of comments before we open it up for questions. First being that I wanted to explain the change, again, from 75 to 65. I wanted to apologize to all of the stakeholders who may have seen the 75% in the original bill, and then we dropped an amendment this morning. It's not my intention to spring anything on anyone. After significant discussions with Ms. Gonzalez, what we started to think about was maybe instead of the median or the mean, we should go with like the median, right? We knew somebody had to lose and some people have to win. But it makes more sense as a policy to go with the 65%. Now, let me also make it very clear. Those folks you are seeing on the tail end of your data set who are serving 100 and something percent, those are largely disciplinary issues. And they will continue to have to serve a decent amount of their minimum percentage, depending upon the parole board and the Department of Corrections assessment of their behavior. There is nothing in this bill that would allow those folks who are perpetually being disciplined to now be guaranteed to get out sooner than they would have otherwise. But we don't really want to punish those folks who are in now or who may go, who will be serving longer under just good behavior than they would have otherwise. And so the 65% number really does make more sense for where we have stuck this nail. I do also think that if we switch to this new scheme, anytime this body would like to consider a harsher punishment, it will be easier. Let's just up the amount of time they've got to serve. And we know what the soonest that they'll be able to get out is whenever we're thinking about what is the right amount of years or punishment to associate with any of the many new crimes that we may create in any given session. It brings transparency. I also personally believe that if you're sentenced and you have that light at the end of the tunnel, you're probably more likely to do good behavior, because you know that if you just hang in there and you do what you're supposed to do, you've got a day. The victims know they've got a day, that they've got to show up for that parole hearing if, it arises and there are no additional disciplinary issues. This is something that we need to move on. And again, I just want to thank Ms. Gonzalez for running through all of that, because she really has done substantial amounts of work to help make sure that this body gets the policy right. And with that, Madam Chair, we will stand for questions.
All right. Senator Nguyen?
And I have a couple of questions, if that's okay. I have been working in this area for 21 years, and it is a disaster. It is a disaster for people when you go onto a website. It might as well be like an ongoing number that kind of changes, or a date that changes. It's impossible to understand. I've had people that they have credit calculations of 0.23 days, and I'm like, what is a 0.23 day? How do you get that kind of credit determination? So I agree with your assessment that we are on a breaking point. I think we've been there for a while, and I appreciate that. It's interesting, and I appreciate you showing us the full data set, because I think a lot of times people come in here and present data. I was just talking with Senator Hansen about this just the other day, about how you are given a slice that kind of promotes and supports your particular stance on any particular issue. So I do appreciate the fact that you have given us a broad scale of that, so you can look at whether or not looking at the mean is appropriate or the medium, on those data point sets. So with that being said, I really appreciate that. When we went back to that slide where you talked about under this new structure where you would see what your date is, you would know what it is right away, and then you saw discipline on there. I know under NRS in Section 3 of the bill, it's still included in there, and it's NRS 209.4465. Those are some of the additional credits that you're able to earn outside of the good time credit, for working or obtaining, you get an extra 60 days for obtaining your high school diploma or your, GED, or 90 days for your high school diploma. I think it's really important that we obviously reward positive behavior. How would that be calculated in there? Would you just be able to subtract those days, and would they show up on there pretty easily under this new scheme?
Thank you for the question, Senator Nguyen, to you through Chair Scheibel. So I'll allow Ms. Gonzalez to supplement. But the reason why you see that remaining in statute is because we are going to allow those folks who are currently incarcerated to be able to choose which scheme will benefit them. And so if you've been sentenced under a current scheme, we're not going to come in and change the scheme to make it where you'd be serving longer than you would otherwise. after everyone who has been incarcerated leaves under the new scheme, those things would go away. And what you would see is that the Department of Correction would have the discipline tool to make your time go longer, but we would not have a system where getting the GED would take time off the minimum. You'd have to do at least the 65 before you were eligible for parole. However, all of those things will be taken into account at your parole hearing. But we just can't go below the minimum. However, I am looking at ways to, let's say you have been disciplined and you want to be able to earn some way to get you back down to your minimum. If there's a mechanism to do that, I'm open to see if we can make that happen. But the minimum will be the minimum. You won't be able to drop below that. But again, it's just an eligibility for parole date as well.
I do. I love the transparency, and I agree with you. I think it's not just for the people that are incarcerated and their families, but I know we've heard in this committee multiple times that we have a hard time getting people, once they have been granted parole, we have a hard time getting them housing. We have a hard time getting those things. And sometimes I think it has to do with, support systems on the outside, whether it's some of our nonprofit, like, reentry programs or family members. They are trying to get housing lined up, but they have like an ever-changing date of when their loved ones might be able to be eligible for parole. And sometimes that can vary between 1 month and 8 months, or 1 month and a year. I would like to see some sort of benefit, because if there is a way to encourage people to better themselves, and, I know you guys are chatting amongst yourself here, just because I think otherwise you have someone who gets their GED, gets their high school diploma, is able to find a way to get their associate's degree, and then a person that sits there and is not causing any discipline, but really isn't doing any of those added steps, doesn't really incentivize some of those programming.
So Victoria Gonzalez for the record. The first point I want to make is that the data that we're presenting to you represents any credits that anybody earned, right? We didn't distinguish between the type of credit that someone earned and what impacted their percentage. So in an attempt to level the playing field, so to speak, for everybody, it's what all possible credits was somebody available to somebody, and then what did they earn and what did they take advantage of and what made sense for them. And so just, the data reflects that, which is why all those separate credits would go away under this scheme and just have that percentage. The second piece of this says that they might are required to comply with their case plan that's based on their risk and needs assessment. So when someone is admitted to the Department of Corrections, a risk and needs assessment is conducted, which evaluates specific to that person, what should this person be working on while they're incarcerated. That plan indicates, for depending on the outcomes of your risk and needs assessment, which is evidence-based, do you need to pursue more education? Do you need this program? Should you be participating in this? That will be laid out in their case plan. And so individuals, to your point, shouldn't be, for those that need that for their case plan versus others who have to work on other things, it'll be tailored to them. So they all get the same percentage, working on what is the plan that makes sense for you to make you successful while you're incarcerated. And then the amendment that we have presented today as well would require the Department of Corrections to provide an evaluation of what were the list of programs and requirements in your case plan, what was available to you, and what were you actually able to participate in. That way the person isn't penalized further if they were supposed to take a program that was never available in the first place.
And Madam Chair, if it's okay, I'd like to ask Mr. Widmer to explain a little bit about the carrots that they have available to them for the type of above and beyond behavior that may be outside of their case plan.
Thank you, Senator. Kirk Widmar for the record. So under our current policies, we have the ability, as was explained, through the disciplinary process for major violations of our Code of Penal Discipline, the ability for us to take for things like assault, murder, arson, the ability to take 60 days away. And under the new scheme, what that will do is add 60 days towards the min. So away from the 65 towards 100% of the min. Now, with positive behavior of the offender, let's say part of the case plan because this individual continues to get engaged in disciplinary, so we modify the case plan and say, hey, we're going to need you to take anger management and a few of these things to help address your ongoing behavior that you continually demonstrate that we need to modify. With success of that, we have the ability already in our policy to restore time that was taken away. So the benefit under the new scheme dealing with this is they become clear and transparent. If we need to take 60 days away for the max, the next level down is 30 days for less major offenses, and the lowest we have is 15 days. So let's say an offender loses 15 days, and after a period of a positive behavior change, the offender can appeal to a full classification committee and request for those 15 days to be restored. That already exists in policy and our ability to manage our population.
And Senator Nguyen, I'll just also mention that in the current scheme today, there is a floor. You can only earn so many good time credits. So once you earn that amount of good time credits under the current scheme, it doesn't matter what you do above and beyond that. You can't earn any more than that. There's always going to be some floor whereby which people will not be able to continue to demonstrate good behavior and get time off, right? So we already have in function a minimum, and I believe Ms. Gonzalez, correct me if I'm wrong. I believe it's around 42% is where it's at currently. You're never going to drop below that under the current scheme. We are doing something similar, but almost kind of flipping it on its head and giving people the benefit of the doubt that they're going to work their plan. But if they don't work their plan, there will be some push out of their date, as opposed to you worked your plan this month, you're up, you didn't work your plan next month, you're back, you then got your GED, you're up again, right? And so it really does try and take into account all of the things people are currently doing and the credits that they're able to earn, but we're always going to have a floor.
And I guess my final question is does this just apply to those nonviolent C, D, and E felonies, or does this include Category B felonies?
Victoria Gonzalez, for the record, it just has the C, D, and E's under the current scheme. So we just proposed, here's what it looks like right now, change it to a percentage, so no additional changes have been made to it.
And does that have to do with all, like, most of C, D, and E's are nonviolent felonies, but there are a couple that are in there. So does it include all of them, despite, no matter what the type of charge it is?
I guess just to be sure, Victoria Gonzalez, for the record. So currently, those who qualify for credits off their minimum are C's, D's, and E's, who are basically not sex, violence,
okay.
DUIs. There's a few
So
exemptions.
that stays the same.
We just took, what was existing and changed it to a percentage.
And so if you can, like, I know under the current structure, so if you are sentenced to a range of sentence of, like, say 12 to 48 months in the Nevada Department of Corrections, you get approximately 42% off of that front number and that back number. Is that on average?
Victoria Gonzalez, for the record. Well, the opportunity to go down 40% is there. The data shows that it's that range.
Around 25 or 35.
Yeah,
I should say
you can
35.
see. I would say between 25 and 35% is what you're looking at is like very common for what people are actually serving for those offenses that we're talking about as they exist in statute.
Okay.
And also, we do have data for all those other offenses. We would be able to tell you how far past their minimum they were released to parole.
Oh. Thank you.
Senator Orenshaw.
Thank you, Chair. And really more of a comment, but I just want to thank Senator Harris and everybody's, collaboratively worked with you on this bill because, my recollection, I've been practicing in juvenile court for a while, but when I was representing adult clients, is that people didn't have some certainty as to what they were working for, folks who were at NDOC. I think it became a lot psychologically harder to try to participate in those programs, try to finish the educational degrees that are available. So I think this bill really has the potential to not only help people be more successful while they're away from their families and incarcerated, but also to help them get back to their families sooner and be more successful once they return to, out of NDOC custody. So thank you, Chair.
Yeah,
you.
thank you, Senator Dallas Harris, for the record. I've never been incarcerated myself, fortunately, but I can only imagine how discouraging it is where you are trying your best to work your program and your date just keeps moving in all these directions and you really don't know why, right? It probably does lead to this idea of like, what am I even doing this for? This will answer that question. Thank you.
Senator Krasner.
Thank you, Chair. Thank you for your presentation. So I just have a few things, because as hard as it is for you to understand, it's even harder for me. So I think the first thing is we always have to keep in mind the victims. We need to keep in mind the victims of crime and their families. Because, here in the United States, we do have due process, so the law enforcement have done their job, the district attorney have prosecuted effectively, and the person has received a fair trial, and now they're incarcerated. So you said that this would apply to C, D, and E felonies. Would it apply to any crimes of violence? Yes or no?
Victoria Gonzalez, for the record, no.
How about sex offenses?
Victoria Gonzalez, for the record, for the minimum, no.
How about lewdness with a child?
Victoria Gonzalez, for the record, I'm pretty sure no. I think that's, no.
Okay.
No.
And then I don't understand the 65, 75, 25, 35. Senator Harris, you said it's 65, 75, and the amendment, it says it's 25, 35. And I apologize. Could you please explain that to me?
Yes, absolutely, Senator Krasner. Thank you for the question to you through Chair Scheibel, Dallas Harris, for the record. So if we wanted to implement you must serve 75%, the bill would put in a 25% number. If we wanted to say you must serve 65% of your time, the bill would put in a 35% number. And so the bill that you had as originally drafted had 25%. We are proposing to make that 35%. You're welcome.
Senator Hansen.
Thanks, Madam Chair. I'm confused like everybody, I think. Your slides and the mathematical calculations were based exclusively on drug and property offenses, including all the charts and bar graphs and so forth?
Victoria Gonzalez, for the record, yes. The data presented in I can look at the page numbers, on the averages, and then the number of occurrences was just C's, D's, and E's for drug and property, and that was the percentage of their minimum that they served before they were released to parole. But we do have data for all the offenses, but it didn't apply, when we're talking about the minimum, it doesn't apply to those other offenses, so that's all it applies to, is just drug and property, C's, D's, and E's off their minimum.
Okay, so you definitely separate them out. That was my question because, I saw in the bill A's and B's are not part of this, sex offenses and so forth are not part. Just want to make sure we're only dealing with property and drug offenses. Obviously my biggest concern is turning people back on the streets who really shouldn't be on the streets, and there's a reason they were given certain sentences and so forth, and we don't want to, I definitely don't want to keep people one day longer than they need to be in there. I also don't want to turn people out back on the streets that could be harming the very people that I'm here to represent, and expect me to be very diligent in keeping the bad guys where they belong.
Yep. Senator Dallas Harris, for the record, thank you for that comment, Senator Hansen, and I think we all agree with you. The parole board, however, will remain. This is just about when is the soonest you are eligible for parole. No guarantees you get out. Victims can show up, make their thoughts heard just like they do today. There's nothing that requires a parole board to release you right at your min. Nothing that prohibits NDOC from adding dates to your parole eligibility date, right? And in my opinion, I think that this actually will be beneficial for victims too, because they will know when they need to show up. They won't have to take a guess either. And if they want to be there to speak and someone happens to be eligible for parole right at their minimum, they will be able to be there. They'll know that date from the moment that person goes in. And the judges will be better equipped to know how long the person they're sentencing is actually going to serve. Right now, it's like anybody's guess. I can sentence you according to the sentence guidelines, but you may serve some variation from 42% all the way up to 108 of that sentence. And so this will be able to make it easier, I think, for judges, for victims, and for, frankly, just everybody.
Well, listening to Senator Wynn's questions, it seems like obviously I have no knowledge whatsoever of how this whole process works. She does. So I'm going somewhat with her judgment on this. It sounds like it's a big convoluted mess at the moment, and your goal here is simply to streamline it and make it much more transparent for everybody involved. Last question. Does this have anything to do with Marcy's Law? Does it affect that in any way?
Madam Chair, if I may just have Mr. Widmer speak to the senator's last point, and then I'll answer that question, sir.
Chair, Kirk Widmar for the record, through you to the senator. One of the things that is, I believe, is very important for the committee to understand as the primary stakeholder in this bill related to these credits is the clear transparency that is developed based on Nevada data. This is our data. This is our representation. This isn't a national trend. This is our data. And so what is very important to us, and working very closely with Director Gonzalez on this, was we need to be careful that the data we present reflects what is actually going on right now under our current scheme. As a department, we cannot afford, with our current staffing and some of those other issues, including areas in your jurisdiction, that we do something that is extreme one way or the other. We have to remain and we have to reflect what is going on in the department now. That's what this bill does. It reflects the data. Policy-wise, what you choose to have that percentage to be, the only advice, if I'm allowed to give a little advice to the committee, is do not stray from what the data is telling you. Because our budget, our population, our staffing, that is all associated directly closely to this. We can't, over the last 5.5 decades or 4.5 decades that we have used credits and complicated this system, whatever side of the policy the aisle was on has got us to this point where we need to make a turn. Give the Department of Correction a chance to be transparent in what we do. Give the Department of Correction a transparency to, once that judge signs that judgment of conviction and applies those jail credits, the rest is easy. The moment that offender leaves that courtroom, they understand exactly when their parole eligibility date can be. The victim will understand that. The DA will understand that. The defense will understand that. It will be as clear as day. The only thing that can affect that is that discipline while they're with us. And again, because the projected credits and all those other types of credits are gone, they're built in already to the percentage. It is a direct movement of days towards that min. And once that happens, again, we publish that on our website. Victims, DAs, judges, anybody can have a clear family. Most importantly, the offender that is serving the time will have that understanding of where their time is. And so from the Department of Corrections point of view on this, please, whatever your decision is, stick to the data.
And that's neutral. That's pretty impressive, I have to admit. Marcy's Law.
And Madam Chair, if I may just get to the senator's questions around Marcy Law, I have never had to notify a victim pursuant to Marcy's Law, so I'm not actually familiar about how easy or difficult that is now. I have heard it is not fun to have that responsibility. It is my opinion that this will, in fact, make it easier for whoever ends up job it's being to do. You can send them a link to the website where the offender's information is. That date will be there, and it won't hop around as much. And so I envision, and I know the district attorneys will come up at some point, I envision that it would in fact be easier for them, but they are probably better suited to answer than I.
Very good. Thank you, Madam Chair.
Okay, Senator Stone.
Thank you, Madam Chair, and thank you, Mr. Widmar, for being here. You bring a lot of credibility being here, and I appreciate you answering the questions to the best of your abilities and what you can do and what you can't do. And Ms. Gonzalez, I'm very impressed with your number crunching capabilities. And Senator Harris, of course, I always appreciate your passion. So it seems like today, again, being another non-attorney, is that this is an archaic maze of uncertainty for everyone, especially you, Mr. Widmar, in corrections. I don't know what kind of a calculator you've got, but it's got to have to be a very complicated one. So this is the way I see this is it's much more simplistic. And Ms. Gonzalez, you made it very clear. I think you said that the baseline today is 42%, and it's going to 65%, right? And so what I see based on your presentation is that this gives a inmate the incentive to behave better and to be able to see the forest through the trees to get to that hearing where maybe they can get out and become a productive member of society. So I just want to thank you for all your efforts.
Thank you, Senator Stone. That's very kind. Dallas Harris, for the record, I did want to note that 42 is it's not what most people are getting. 42 is the most someone could get right now. Yeah. Okay. Thank you.
All right, any other questions? Yeah, Senator Wynn.
I think I like this bill even more now. Anyway, I just want, and I know that this is so complicated. I don't know if it's like conveyed on how complicated our current model and current system is. I think you are the one person that even understands, and all of this falls on you. So I know that there's a lot of like litigation. I don't know if there's anyone from the AG's office, but I know they get a lot of like complaints, and there's a lot of like unnecessary litigation around like these good time calculations because no one understands them. Do you anticipate that this would eliminate this? And how much of your job is dedicated to trying to explain this convoluted system to families, the courts? I've had cases where I've had to come in like multiple times for a judge to explain what their sentence was because it didn't fall into like this weird model of calculation that we had.
Kirk Widmar for the record, and Senator Wynn, thank you so much for that question. I had the opportunity at the Interim Joint Committee to testify to the group as a whole and got to sit in the hot seat trying to explain this. Senator Harris, Senator Scheibel, members of the committee ran me through the ringer in trying to explain this. And so I absolutely appreciate the question. I spend my staff, and if I can have a little indulgence, my staff are an incredible team. They're an incredible team that do an incredible job to make sure that they're upholding the laws of this state related to sentence calculation. And they work their butts off. It can't be said enough. The important thing to understand that when I exposed who I was during that interim committee, I have spent several opportunities with judges, with DAs, with public defenders, trying to do that education as to what we are doing. How do we calculate? Litigation is often, yes. We tend to be successful in litigation because after we have the opportunity to sit down and explain it through, there's an understanding of what took place. If I could just share a simple example that I recently had, I was subpoenaed into a federal court and had the opportunity to, on an emergency motion, that from the very beginning, the federal magistrate recognized that they did not have the authority to make a ruling on something that was a state issue related to parole. However, when their staff and they went through and tried to understand Nevada law to see if harm had been done, even though she fully recognized she did not have the authority under her jurisdiction, I spent the next 4.5 hours in the hot seat explaining to her what we did to calculate the sentence to ensure we did not create harm to the offender, which would be under her jurisdiction. And so it's important to understand that man hours are uncountable, hundreds of phone calls a month that my staff field trying to answer questions. Litigation abounds, and it abounds out of ignorance. It abounds out of not understanding what we are doing. When we're given that opportunity and put in the hot seat, sure, we can get it explained out, but that's not fair. That's not fair to what we do as a state. It's not fair to what we represent as a department. And so I hope that answered the question. I'm very passionate on this subject.
No, I appreciate that. And I did want to give you the opportunity because I know that this brings so much clarity and so much transparency to a system that is so convoluted. And we don't want you wasting resources. We don't want the attorney generals having to go to court. We don't want you being subpoenaed to a federal district court to explain successfully. But the fact that it would take you 4 hours to explain a process, I think should tell us everything we know about our system that we have in place. So I appreciate that.
All right, Senator Stone.
More. Thank you, Madam Chair. Appreciate it again. It seems to me also that maybe we've been kind of discussing that by instituting this much more transparent system, I'm sure you hear some cases of some convicts saying, "Hey, this is bias. You're discriminating against me. You're giving me more time because of the color of my skin," or so they would. Some could make a claim that the decisions that you make are arbitrary and capricious, right? So by having the system in place, it would be much more transparent, much more explainable, so you could defend against those type of accusations against you. And then lastly, I want to say, again, Ms. Gonzalez, I'm so impressed with your number crunching capabilities that if you ever need a letter of recommendation to the Internal Revenue Service, I would like to write that letter for you.
Thank you for that, Senator Stone. We're really trying to do something that makes sense here. Is there a perfect number? I don't know. We can always argue one way or the other. But again, especially to Senator Hansen's point, if you take a look at slide 8, you'll see that right now, 54% are about to the left side of the line we've picked, which means 46% are to the right. So we've tried to find something that is square and in the middle and represents what is already happening. And as to Senator Wynn's point, it's not my intention to put anybody out of the job. So just to make it quite a bit easier.
Thank you very much, Senator Harris. Members, any additional questions for Senator Harris and the other presenters? All right, not seeing any additional questions, I'd now like to open it up for support for Senate Bill 413. I will start here in Carson City, and we are limiting it to 2 minutes per witness. Please state your name for the record and proceed.
Thank you, Vice Chair and committee members. My name is Nick Shepak, S-H-E-P-A-C-K. Today I'm here as the board chair of Return Strong. I had the absolute lucky opportunity to hear this presentation twice now, so I believe I understand it. And I can take us back to that interim Judiciary Committee where we shared a collective sense of mass confusion. I think the looks on everybody's face through that hearing told us all we needed to know. One of the number one complaints we hear from our members at Return Strong is that they are confused about when they're getting out. Their families don't know when they're getting out. They think it's going to be now, it's later. We believe that this solves this, and we believe that this is a data-driven solution. And on top of that, we currently have a system that favors you if you are a high IQ native English speaker. You have more opportunities for different jobs. You have more opportunities for different education. Somebody who speaks a language that maybe Tagalog or something that is incarcerated doesn't always have the same opportunities to earn those credits, but they may be a model incarcerated individual. By treating people who aren't causing problems all the same, we move towards a more equitable system, one that everybody can understand, from victims to the incarcerated to their families. We think this is long overdue, and we're very happy, and we do not send Victoria Gonzalez to the IRS, please. Thank you.
Thank you very much for your testimony. Please state your name for the record and proceed.
Good afternoon, members of the committee. Erica Roth, E-R-I-C-A-R-O-T-H, on behalf of both the Washoe and Clark County Public Defender's Office. You all probably saw me scurrying around in the back because this is how confusing all of this is, and when you started throwing numbers around, there is a joke that lawyers can't do do math. And whenever a client would ask, do numbers, can't do math. And whenever a client would ask me what their good credit would be, I would say, well, that's prison math, and we definitely can't do that. It is very confusing. I think that the 65% is a fair compromise. It's not exactly what I would have asked for, but I think when you look down and you look at the data, it's a reasonable place to literally meet in the middle and try to address this issue. It is incredibly confusing. People do not know when they're getting out. It will provide clarity both to my clients and to victims of crime, and so I urge your support. Thank you.
Thank you very much for your testimony. Anyone else here in Carson City? Right, down to the Sawyer Building. Testimony and support.
Good afternoon. My name is Ashley Gaddis, Gaddis, and I have formerly been incarcerated at Florence McClure and currently staffed with Return Strong. So there's an unfortunate and fortunate side to my testimony today. I would start with the unfortunate side. I have been in and out of NDOC since 2000. I have fought many battles with the DOC regarding time computation and release dates that all have resulted with no resolution or explanation that makes sense. As is, the current statute is very confusing. The fortunate side to this is I have become very familiar with the NRS 209-4465 that was added to Chapter 209 dated back to 1977. And I understand it. I'm here today to express share my story and support the change that this bill will present if passed. I could go back in history, but I will focus on the current problem as the history is repetitive in nature. When entering the DOC, we are given probable release dates that have been pre-calculated based on good time, work time, meaning that you must work, program, and stay disciplinary free to keep those dates of release. Since the days have been given as credit, they can and are taken back if the requirements are not met. The requirements have become unrealistic and even obsolete in some institutions due to the lack of jobs available to the population, lack of programming, and the constant random lockdowns that remain an issue. While all the above may vary based on the institution, what does not vary is the end results, and that is a loss of good time, work time that was initially calculated, which also affects the projected release date. Not having a solid release date upon entering a prison is a very defeated and hopeless feeling. Even more so after the disappointment comes from telling your family that you will be home for Christmas based on the projected release date and knowing that you've done nothing wrong, to lose those days and lost them through no fault of your own, but through missing class or work through lockdowns or for whatever reason except your own misconduct. I understand this bill will calculate good time, work time using a percent that pretty much is a guaranteed release unless there are disciplinary issues. I support this bill and urge the passing of this bill. The world and other state prisons continue to evolve. There is no reason why Nevada can't evolve into a system that works and makes sense. Thank you.
Hi, my name is Pamela Browning. I am staff of Return Strong, and one of the reasons I reached out to Return Strong and got involved is not only other things going on within the institutions that are really crazy, but the sentencing. I am formerly incarcerated, but in a different state. And when I was sentenced, I knew when I was coming home. My loved one never knows when he's coming home. And that is, I just know how important it is when you're trying to do right, but you don't see light at the end of the tunnel. But I support this bill with the 100%. I think it would give people something to look forward to and really work towards and cut down a lot of the disciplinaries going on. Thank you.
Thank you so much. Excuse me. Thank you for your testimony. Thank you, Senator Orenshaw, for your help. I don't see anybody else coming to the table to testify in Las Vegas, so let's go to the phone for support testimony on SB 413.
Thank you, Chair. If you would like to testify in support of SB 413, please press star 9 to take your place in the queue.
Tanya Brown, TONJABROWN, advocates for the inmates and the innocent. We support AB 413. This is a typical application to new nonviolent offenders. And we say that the Department of Corrections should be the one to apply these credits. Now, I want to echo the comments made by all the previous people who have made very good suggestions and on how this is working and all their comments. But I want to add something else. The NDOC should be the mechanism in order to correct these disciplinary actions. Some of you are not aware of this, but I am privy to this, so I know what I speak of. There are disciplinary actions found in inmates' files, and this is submitted to the parole board. The parole board has no way of knowing whether or not those disciplinary actions were ever totally grieved. They were upheld on appeal, but they had been litigated in court, and the court issued an order in favor of the inmate. These courts and the inmate would have this information, but it is not referenced in the NDOC file. So when the parole board sees this information, they see that those disciplinary actions should have been removed. And for the NDOC to be the mechanism to go in and remove those disciplinary charges will free up and return all those credits back to the inmate and would more than likely be given a favorable parole. So this is just something that has not been brought up, and I'll tell you that over the years there has been a lot of discussions over the credits and how this is in the sentencing structures under Biffith and Bowen and so on and so forth. It is complicated, but there is some legislation that kind of even tones it down and gives a better understanding than what was presented today. I just wanted to give that to you, but we are in strong support of this bill, and thank you.
That concludes our callers to testify in support at this time.
All right, then we will move to testimony in opposition, starting in person in Carson City. Go ahead whenever you're ready.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, and I'm here on behalf of the Nevada District Attorneys Association in opposition to the bill. I want to start off by saying truth in sentencing to DAs around this state is when a judge sentences someone to 12 months at a minimum, that they serve 12 months. That when a victim is told a defendant is going to serve 12 months, that they serve 12 months. Now, we understand that this is not the current structure that we have in Nevada. And I understand, and I will say something that I do not say very often here in Senate Judiciary, that I completely agree with Senator Harris. Our current sentencing structure is an absolute mess. Defense attorneys, defendants, victims, prosecutors, judges, nobody understands it and nobody likes it. But we have to be very careful about what we replace it with. Better the devil you know sort of argument here. I will say I was close to coming in support when I read the first bill as drafted with the 75% number. I was a little dismayed, to be perfectly honest with you, when I saw the amendment just reducing it to 65%. As many of you know, our prison population has been trending down in recent years, and I can confidently say that the people that we have placed in the Nevada Department of Corrections are those whose offense or whose criminal history warrant them being in the Nevada Department of Corrections. And with that in mind, I don't necessarily think that picking the lower of the median or mean is the best approach to, quote, codifying our current system. I think it's a little more complicated than that. So with that, I do want to end by saying I appreciate Senator Harris for having several conversations with us on this bill. I appreciate Executive Director Gonzalez meeting with us on several occasions and discussing this bill. We are committed to working on making truth in sentencing happen in Nevada. Thank you, Chair.
Thank you, Mr. Jones. Can you guess what I'm going to say next? Senator Hansen has a question for you.
Surprise, the Marcy's Law question. Can you address that? I don't know if this bill will affect that in any way, and that's a constitutional thing that voters pass. So,
Thank you, Senator Hansen. That is a great question. It's my understanding that this will not affect a victim's right to participate in a parole hearing. And it is their constitutional right to participate in that hearing. And generally how we do that now is through the VINE system. It's a system in which victims can go and request notification when a parole hearing is coming up. And I see nothing in this bill that would affect that. Now, I do want to say that our current system is confusing to victims, that much like defendants, victims have no idea when a person is going to be eligible for parole. I would submit to you that under what DAs want, a true truth in sentencing model, if a judge sentences you to 12 months and you have to serve 12 months, then it's really easy for everybody to know how much a defendant is going to serve. It will be at least that 12-month period of time.
okay, well, that's something, that's a very common thing that lots of people like. I mean, the idea of, now maybe if our sentences are too long and that's why there's a lack of reasonableness in it, maybe we can clean that up. But that whole concept of, I can't tell you how many times I've had people say, well, if they're sentenced for 2 years, they should serve 2 years, damn it. That kind of an attitude. Question, you mentioned the population of our prisons are trending down. What's the crime rate doing, though? Is it for the state, not just Clark County, do you know?
John Jones on behalf of the Nevada District Attorneys Association. I don't have those exact crime statistics in front of me, Senator, but from my understanding that they are trending up.
Okay, well, the reason I bring that up is I remember the whole 3 strikes you're out fight from 20, 30 years ago now. And I remember as the prison population went up, we also saw a significant decline in crime rate. So, we want to have a happy medium. Question on that, though, on the crime rates that you think are trending up, how many of those are drug and property related versus, the more serious violent offenses?
John Jones on behalf of the Nevada District Attorneys Association. Senator, I would love to have this discussion with you. I just don't have those statistics in front of me, and I don't want to speculate.
Okay, very good. Thank you, Madam Chair.
All right, thank you. Excuse me. Anybody else wishing to give opposition testimony in person? Not seeing anybody, we will go to the phones.
If you would like to testify in opposition to SB 413, please press star 9 to take your place in the queue.
Hello, committee. This is John Carlo, and I just wanted to ask, is it within the jurisdiction of this committee to be able to add tighter punishments on criminals and bringing down the crime rate in Clark County and the cost of living that's associated with that? That's all my question is, if you guys can add that to this bill. Basically, my understanding, we haven't had corporal punishment on when I was raised in the South, I got spanked, and there are still states that are doing that. There's teachers getting attacked, and this is not going on across America. This is going on right here, and also capital punishment. It's been a very long time, and you guys are arguing about the money. Is these people, Jesus said, should, this is a biblical stance, is capital punishment. But I wish you guys a very good evening, and these are the concerns that we have. Thank you.
Hello? Hello?
Go ahead.
Mercedes Maharis for the record. I'm sorry that my submission was late. I have a chart that I would like for you to see on an example of the bouncing back and forth ping pong days. And I am in opposition of this bill because the days, nobody's going to get credits, as I understand it this morning, from a policy analyst who has A, B, C, or D in Section 1. Violence, sex, DUIs, and A or B felonies. I believe that these individuals have not been treated and are not getting treated for mental and physical health care, which brought them to prison and their crimes in the first place. I think that I see this as overt discrimination, and it's wrong, and I can't support the bill because of that. In fact, I don't know why the sex offenders and DUI people would be put in this category, because the reports on recidivism say that these two categories, alcohol addiction, sex addiction, are the least likely to reoffend in the past two NDOC reports. So I see this as discrimination against the unfortunates who haven't had education or treatment, and I think it's wrong, wrong, wrong. Please look at the chart that I submitted. It will show you the chaos that goes on in individuals' lives concerning the changing dates of release. Wishing peace and prosperity for all, I remain Mercedes Maharis, Las Vegas, Nevada.
Hi, Katrin Ivanov, aka Mrs. Fixit. For the record, I-V-A-N-O Frank. I oppose this bill. As before me was said, when someone has a minimum sentence, they should serve their minimum sentence. Furthermore, if we make bigger sentences for crimes, there's going to be less crimes. I apologize. When I was in Asia, I was looking for my kids, and somebody turned to me and said, "Oh, don't worry, nobody's going to touch your kids." I said, "What are you talking about?" They said the penalty to kidnap them, not even do anything else to them, just to kidnap them, was death. So they didn't have kidnappings and problems like that. So when people are faced with severe penalties, they think more seriously if they're going to commit a crime or not. Is there going to be sick individuals that are going to continue committing crime? Absolutely. But there's going to be a lot of people that's going to be deterred if there are stronger sentences. The biggest problem I have with this bill is that trying to get rid of the minimum sentence given by a judge. Thank you for your time.
That concludes callers testifying in opposition.
Thank you. We will move to testimony in neutral. Anybody wishing to give neutral testimony in person is invited to the table. But not seeing anybody, we will go to the phones, please, for neutral testimony.
If you would like to testify in neutral for SB 413, please press star 9 to take your place in the queue. We have no callers testifying in neutral at this time.
All right. Any closing remarks? Please, count up.
Thank you, Chair Scheibel. I just wanted to clarify a couple of things. One, this is not a guaranteed release date. This is just when you are eligible to go before the parole board. They will make a determination of whether you are released or not. Nothing changes about how that process currently works. I also wanted to let you all know, I didn't pick the 65 number because it's lower than 75. I picked the 65 number because I think it better reflects what is happening today, and that we did not want to discourage people from good behavior and offer something that actually gets those good folks serving longer than they would have been. But we also don't want to let bad folks out sooner. And I just think 65 is a better reflection of those numbers. When you see those folks who are on the other side of that 65% line, they will continue to be there, because those are those folks who have those disciplinary issues that will continue to push them out. You will still see folks who are serving 108% of their min if they've earned that 108% of their min because of their behavior, right? So there's nothing that will pull those people closer to the 65. That's not how this will actually work in practice. 65 will just be the best you can get if you behave on your very, very best behavior. But we won't be calculating these averages anymore moving forward. And I do really believe, I think the best thing about this bill, and anyone who's sat on Judiciary for long enough, Senator Hansen, you'll know, is that you'll never have to see another bill with the good time credit in it ever again. Thank you, Madam Chair.
Thank you so much. All right, that brings us to the conclusion of SB 413. I will now close that hearing. We will move now to our work session. Sorry, but I have all of my members here, so I have to strike while the iron is hot. Yes, so we have, I think I said 13 bills on our, 12 bills on our work session this afternoon. I will turn it over to Mr. Guinan.
Thanks, Chair. Pat Guinan for the record. We're going to try to go through this quickly. So on some of these bills with longer summaries, unless the committee would like me to, I'm not going to go through the entire summary. That will be the case with the first one, which is Senate Bill 63, which is a committee bill that was brought on behalf of the Nevada Supreme Court. The committee will remember that this is sort of the court's cleanup bill, technical changes, revisions, things like that. So I'm not going to go through it all. I will just speak to the amendment. The amendment is proposed by the Judiciary. It's attached for the members' review. The amendment retains the current statutory provisions regarding judicial disqualification and adds provisions to better manage disqualification filings and replies to such by judges. It clarifies that the provision of resources for the Supreme Court is the duty of the state. It revises provisions in Section 27 to clarify the obligations of a county in providing resources to a district court. It provides that part-time judges may practice law in a firm or with a partner so long as certain conditions are met, and adds a new Section 31.5 to the bill to include full faith and credit provisions regarding orders for protection against high-risk behavior, as currently exists for other types of protection orders. That's all I have, Chair.
All right, any questions? I would accept a motion to amend and do pass. I have a motion from Vice Chair Harris. I have a second from Senator Wynn. Any discussion? Yes, Senator Orenshaw.
Chair Scheibel, I am going to vote to support this out of committee. I just want to reserve my right. I just have a couple of questions I still have about the disqualification part.
Understood. All right, all those in favor say aye. Aye. Any opposed, nay. The motion passes unanimously. And do I have a volunteer for the floor statement? I will give it to Senator Dondero Loop.
Thanks, Chair. Patrick Guinan again. We're now on Senate Bill 103. This is a committee bill, and it revises provisions governing the Nevada Sentencing Commission within the Department of Sentencing Policy. It was heard here on February 13th. SB 103 revises the membership of the Nevada Sentencing Commission to include the Chief of Staff to the Governor or their designee, a District Attorney, a representative of the Central Repository for Nevada Records of Criminal History, a member with expertise in sentencing policy and practice, and a member of the Nevada System of Higher Education. It also prescribes certain requirements for a member who is a District Attorney and allows the Commission to establish working groups, task forces, and other entities to assist in its work. It revises the commission's duties slightly to clarify that the commission is to evaluate and study practices and policies related to sentencing, and it requires the commission specifically to conduct a study of sentences imposed for misdemeanor offenses and report its findings and recommendations to the Joint Interim Standing Committee on the Judiciary and to the Legislative Council Bureau ahead of the 83rd session of the legislature. There are no amendments.
Any questions? All right, I would accept a motion to do pass. I have a motion from Vice Chair Harris and a second from Senator Orenshaw. Any discussion? All right then. All in favor say aye. Aye. Any opposed, nay. The motion passes unanimously. Do I have a volunteer for the floor statement? I'll take it. Wow, 3 volunteers, but I'll give it to Vice Chair Harris.
Patrick Guinan for the record again. We're at Senate Bill 129 now. This is a bill revising provisions relating to civil actions involving sexual assault. It's sponsored by Senator Krasner and others. It was heard here on the 21st of February. SB 129 sets forth guidelines for a person who was the victim of sexual assault as an adult to bring a civil lawsuit against an alleged perpetrator or a person who was convicted of the sexual assault, and provides that such a lawsuit may be brought at any time after the assault occurred. If the plaintiff's alleged injury is the result of 2 or more sexual assaults, the plaintiff is not required to identify which of those assaults specifically caused the injury. For the purposes of actions brought under this bill, the definition of sexual assault is imported from criminal statute into statutes governing civil actions of this nature. The provisions of the bill apply retroactively to any act constituting sexual assault, regardless of any pertinent statute that was in effect at the time of the assault. There are no amendments.
All right, any questions? I would accept a motion to do pass. All right, we have a motion from Senator Harris and a second from Senator Orenshaw. Any discussion on the motion? All right, seeing none, all those in favor say aye. Aye. Any opposed, nay. The motion passes unanimously, and I will give this floor statement to Senator Krasner.
Thanks, Senator. All right, we're at Senate Bill 153 now. This is a bill relating to corrections. It is sponsored by Chair Scheibel and others. It was heard here on March 21st. SB 153 requires the Director of the Nevada Department of Corrections, with the approval of the State Board of Prison Commissioners, to adopt regulations governing each institution and facility of the department, addressing the supervision, custody, care, security, housing, and medical and mental health treatment of offenders who are gender non-binary, gender non-conforming, intersex, and transgender. Generally accepted standards of care and best practices must be followed, including the use of respectful and up-to-date terminology that accounts for and protects these offenders' rights and prohibits discrimination. Additionally, the bill requires that training and cultural competency for interacting with these populations be included in staff training programs. There are no amendments.
Thank you. Any questions? All right, I don't see any questions. I would accept a motion to do pass. All right, we have a motion from Senator Orenshaw, a second from Senator Wynn. Any discussion on the motion? All right then, all in favor say aye. Aye. Any opposed, nay. All right, for the record, it looks like Senators Stone and Hansen are the nays. The rest are ayes, and I will take the floor statement on this one.
Patrick Guinan for the record. We're now on Senate Bill 172. This is a bill that revises provisions governing the ability of a minor to consent to health care services. It is sponsored by Senator Harris and others. We heard it here on the 9th of March. SB 172 provides that a minor may give express consent to a physician assistant, a registered nurse, or a pharmacist for the provision of health services to prevent sexually transmitted diseases, including prescribing, dispensing, or administering a contraceptive drug or device without the consent or notification of the minor's parent or legal guardian. The bill also provides that a physician assistant, registered nurse, or pharmacist who is an employee or volunteer at a family resource center that has received grant funding is authorized to examine and treat a minor who is suspected to have been infected with a sexually transmitted disease without consent of a parent or a legal guardian. There is an amendment proposed by Senator Harris, which is attached for the members' review on the following pages. In summary, the amendment revises language in Section 1 to clarify that a minor may give express consent for the services named in the bill. It revises language for consistency between subsections 1 and 2 of Section 1 of the bill. It adds a physician assistant and registered nurse to the list of those who may examine and treat a minor for any sexually transmitted disease, and it adds an Oxford comma where appropriate. That's all I have, Chair.
Thank you. Any questions? All right. Excuse me. I would accept a motion to amend and do pass. All right, we have a motion from Senator Nguyen, a second from Senator Orenshaw. Is there any discussion on the motion? Senator Stone.
Thank you, Madam Chair. I regret I can't support SB 172 as I cannot support a minor getting any kind of health care without the consent of their parents, including immunizations. Thank you.
All right, Senator Hansen.
Thank you, Madam Chair. I ditto that. To have a law that says without the consent or notification of parents or legal guardians of the minor just is completely unacceptable. There should be no medical practices of any type or any medicines ever issued for a child where the parents are not even notified. I mean, it's exceptionally serious things that can happen irrespective of the questions of sexually transmitted diseases, abortions, and so forth. So this bill just goes way too far. Thank you for the indulgence, Madam Chair.
Of course, not seeing any further discussion. All those in favor say aye. Aye. Any opposed, nay. It looks like Senators Stone, Krasner, and Hansen are the nays. The rest are yays.
Patrick.
Sorry, floor statement will go to Senator Harris.
Pardon me. Patrick Guinan for the record. We're now on Senate Bill 211. This is a bill that revises provisions relating to marriage. It's also sponsored by Senator Harris. We heard it here on the 16th of March. The bill provides that if a marriage was solemnized in this state and a spouse changes his or her name via court order, the county clerk or county recorder is to issue a corrected marriage certificate, including the spouse's new name, upon a receipt of the copy of a court order, an application from the spouse, and an affidavit of correction of the marriage certificate and any applicable fees. The county clerk is to maintain both the original marriage certificate and the corrected certificate as a public record. There is an amendment Senator Harris proposed, and it is attached. In summary, the amendment provides that a county clerk or county recorder can accept a court-ordered name change from any state in order to amend a marriage certificate. It changes the term corrected certificate to amended certificate. It adds that an affidavit of amendment must be notarized, prepared by the county clerk, and executed by the married couple. It adds quote-unquote county recorder in Section 2 where necessary, and adds provisions in Section 2 providing that an uncertified marriage certificate shall be given to the married persons and prescribes the form to be used for that certificate. That's all.
All right, any questions? I don't see any questions, so I would accept a motion to amend and do pass.
Second.
All right, we have a motion from Senator Nguyen, a second from Senator Orenshaw. Any discussion on the motion? All right, all in favor say aye. Aye. Any opposed, nay. All right, looks like it's a unanimous vote in favor of amend and do pass, and I will assign the floor statement to Senator Harris.
Okay, we are now at Senate Bill 243, which revises provisions relating to catalytic converters. This is sponsored by Senator Nguyen and others. We heard it here on the 23rd of March. I don't know if I'm going to go through this whole summary, Chair. I don't think it's necessary. I think the members are familiar with the catalytic converter bill. So I'll just read the amendment really quickly and let everybody know what's in it. Is that all right? Or do you want to just move on?
Anybody need him to read the amendment statement? Any questions? All right. In that case, I will accept a motion to amend and do pass. We have a motion from Senator Orenshaw and a second from Senator Nguyen. And any discussion on the motion? All those in favor? Well, Senator Harris.
Sorry, Madam Chair, thank you. I do intend to support this bill out of committee today, but I want to give the amendment a fresh look, do a little bit more thinking, and would like to reserve my right.
All right. Not seeing any further discussion. All those in favor say aye. Aye. Any opposed, nay. It is a unanimous vote, and I will give the floor statement to Senator Nguyen.
Next, we have Senate Bill 266, which relates to entry fees for participations in a contest or tournament being excluded from gross revenue for the purposes of gaming license revenue. It's sponsored by Senator Pizzina. We heard it here on March 29th. Chair, do you want me to go through the summary or no?
I don't think so, unless anybody else wants him to. Okay. And for those of you who are following along, the work session document is also available online, just so you know. Any questions on SB 266?
Move approval.
All right, we have a motion from Senator Stone to amend and do pass, and a second from Senator Orenshaw. All those in favor say aye. Aye. Any opposed, nay. It is a unanimous motion. Unanimous, and I will give the floor statement to Senator Pazina.
Thanks, Chair. We're now at Senate Bill 289, sponsored by Senator Nguyen. This one expands the definition of a provider of health care for certain circumstances. We heard it here on March 27th. There is an amendment. There are two amendments, actually. Both are explained here. If you want me to go through them, I will. Otherwise, I'll leave it up to you.
Any questions? All right. I would accept a motion to amend and do pass. All right, we have a motion from Senator Stone, a second from Senator Orenshaw, and some discussion on the motion. Go ahead, Senator Harris.
Thank you, Madam Chair. I generally am not a fan of upping penalties, although I do understand why we want to ensure that there is an equal amount of treatment amongst all hospital workers. I will support this bill out of committee today, but would again like to reserve my right.
Understood. Any further discussion? All right, then, all in favor, aye. Aye. Any opposed, nay. Another unanimous motion, and I will assign the floor statement to Senator Nguyen.
Right. Next bill is SB 316. This is the chair's bill. It was heard here on the 29th of March. It adds the name of a defendant and the associated case number to a report that a district attorney must submit to the Attorney General annually concerning cases that included charge of murder or voluntary manslaughter. The chair suggested an amendment at the hearing to transfer these duties to the Nevada Sentencing Commission. So that is the amendment that's included. That's all I have, Chair.
All right, any questions? Not seeing any, I would accept a motion to amend and do pass. All right, we have a motion from Senator Nguyen and a second from Senator Harris. All in favor say aye. Aye. Any opposed, nay. The motion is unanimous, and I will take the floor statement.
Next is Senate Bill 368. This relates to real property. It was sponsored by Senator Harris. It deals with covenants and restrictions, and I'm pretty sure the members remember there is a fairly large amendment. I don't know if Senator Harris wants to discuss it or if the committee wants it explained, but I'll leave it up to you, Chair.
All right, anybody have questions or want Senator Harris to walk through the amendment? It sounds like everyone's okay. I would accept a motion to amend and do pass. Oh, okay. That was a motion from Senator Krasner, seconded by Senator Nguyen. Any discussion on the motion? Not seeing any. All those in favor, aye. Aye. Any opposed, nay. All right. Another unanimous motion to amend and do pass, and this floor statement will also go to Senator Harris.
Last bill today, committee, is SB 382, which is a committee bill relating to juveniles. Chair Scheibel presented this bill. It deals with appointing counsel for an adverse party in an action against a juvenile. Do you want to go farther than that, or do you feel comfortable, Chair?
I'll just go ahead and explain that there was one additional amendment since the hearing, which is to include juvenile delinquency proceedings in addition to criminal proceedings, because those are the proceedings that juveniles go through, and they're the subject of the bill. So if there are any other questions, now is the time. Not seeing any, I would accept a motion to amend and do pass. All right, I have a motion from Senator Harris and a second from Senator Nguyen. All in favor, aye. Aye. Any opposed, nay. All right, it is a unanimous motion to amend and do pass, and I will take the floor statement. And I think that's the last bill in our work session, right? We did it. And with that, we will move on to our next bill hearing. Do you want to take them in order? Yes? Okay. Okay, then I will open up the hearing on SB 362.
Okay, so good afternoon. I'm Senator Dina Neal, and I have Caleb Green from Dickinson and Wright here to co-present on SB 362. The bill does a couple of things. Well, actually, it does three things. The first portion of the bill, which is Section 1, is something that, over the interim, we saw a lot of interaction with police where a person was saying they can't breathe, and they might have had some kind of medical issue or medical incident. And this is just kind of codifying what could potentially already be police policy to ensure that if a peace officer encounters a person that is saying that they can't breathe, to render medical aid. In addition, Section 4 of the bill, because I'm going to tie those two pieces together, I brought those pieces because there were stories in the media where not just simply not being able to breathe, but actually having an underlying medical condition that created the inability to breathe. So there were several incidents where we have hidden diseases such as sickle cell, lupus, and other diseases that a person may encounter. So there was a couple of incidents that happened over the biennium where a guy named Martin Anderson, he suffered from complications in Panama City, Florida, and saying that he couldn't breathe. But what happened was he had a sickle cell reaction. If you are familiar with sickle cell, literally the sickle shape of the cell moves through the body, and what it can do is constrict blood flow if you actually have a sickle cell reaction. And so the officer's thinking he ran, right? Therefore, he must be able to breathe, and this may be an excuse, not knowing the underlying condition that the person may be carrying, because not all diseases are seen on the surface, was the reason why I brought Section 1, but also brought Section 4. And so I'm going to talk about these two pieces before I turn it over to Attorney Green. Because when I looked at, okay, how can we deal with this? How can we deal with this in a way where, how would an officer even know, right? And I found out that in 2007, we actually had passed a law that allowed us to put information or code in the NAC that said that someone may have a certain kind of disease. There were like 6 or 7 diseases that were put in statute in 2007. So I looked at how can I modernize the 2007 statute and then bring it forward so that if a police stop happens, that a person has a medical symbol on their license that indicates there is an underlying disease present that we may need to ask some additional questions about in the stop. And so I thought it was a clear way to try to not only promote safety on both sides, safety for the person that stopped, safety on the peace officer side in terms of the wisdom for the stop, the discernment for the stop. The bill does not mandate it, but it makes it permissive that a person can go voluntarily put and ask for their information to be uploaded into DMV so that when a police stop happens, the peace officer can pull up this code that is being indicated by the symbol on the license. So what is that symbol? So I took the time, and you guys should have this. I have my graphic artist, because this is what's in my mind. I had my graphic artist design this for me as a symbol that could go onto the license. So I wanted to play on what AMA does, but also using Nevada and then using the medical serpent to come through, because I kept thinking, okay, well, what would that symbol be, right? And then I was like, it has to be a symbol that at least represents some form of medicine, not being able to use the AMA symbol, which is copywritten. But to allow a conversation about if someone voluntarily says, I go to DMV, I have an underlying disease, I have schizophrenia, I have a mental illness, I have other things that I would like to denote so that when I'm stopped, if I do have a reaction, the peace officer at least is aware that something else is going on, which makes them ask that additional question. And if a person can't talk, then they're at least allowed to then pull that license, pull that code, and then say, oh, it looks like, such and such is deaf. Such and such has, has suffered a stroke in the past, or if that's something that they wanted to put in there, and this may be a situation. Or in the case of a seizure, there have been plenty of instances where I've known of constituents who are driving and have a seizure, and there is no one around who can identify the fact that there may be an epileptic episode or just a seizure in general. And one of my neighbors actually had a seizure, and his car ran through the light. As dangerous as that is, the only other person that knows what his underlying condition is him, who potentially is without speech, who is potentially not able to vocalize or express what is going on. But now the driver's license would have a symbol, if this bill was to pass, to say, hey, I pulled the code. It's showing that he has epilepsy. It's showing that he has some other underlying condition, and therefore action happens, right? Because what we don't want to happen is the death that we can prevent. We know that protocol, if you know that someone is having an emergency, you should call emergency response. But we also know that for certain instances, we are trained, right, in CPR and other instances to render preliminary aid if we know what's going on. And also, as we have seen this increase in mental health crisis in Nevada, be it a teenager or an adult who may be facing some kind of mental health crisis, this also helps to treat the situation differently, because now you have gained wisdom from the driver's license or ID that now tells you, you know what, this person may have some other things going on that I may be apprehensive about, but now I consider the medical condition that I'm faced with and maybe have a different response and different approach. So that's what Section 1 and Section 4 were trying to get at. And because of the news stories that I had been seeing and trying to figure out what then is the solution, how do you figure out how to identify and let folks know, peace officers know who are engaged in a stop, that there may be an underlying medical condition. It just so happened that Tick Sagerbloom in 2007 thought about this before me, but he had a 6-digit code. I was like, I don't really know what the 6-digit code means. So I was just like, let me do something more simple and create a symbol. And with that, I will turn over Section 2 to Mr. Green.
Thank you, Senator Neal. For the record, my name is Caleb Green. Thank you, Vice Chair Harris and the Judiciary Committee. This by way of some background. As mentioned, I work at Dickinson Wright. I am an intellectual property attorney by trade. Just some background, graduated from the William S. Boyd School of Law, have where I got my law degree with a concentration in intellectual property law, a member of the Nevada State Bar section of IP, as well as the National Bar Association and the American Bar Association intellectual property section, where I'm also a young lawyer fellow. Addressing Section 2 of the bill as it relates to copyright, effectively what this section is doing would prevent what many legal scholars call the weaponization of copyright law by peace officers. And you may be asking yourself, what does that mean? That sounds like a really big word. You should have received a few examples of some other publications of examples of this purposeful use of or misuse of copyright law by police officers throughout the country. It's something we've seen on the rise since the summer of 2020. And is in way using copyright in a way that was not intended to censor the sharing of recordings, lawful recordings of law enforcement, by law enforcement actually playing or causing copyrighted music to be played while they're being recorded by a lawful individual. So some of those examples, I think one that was pertinent was there was one in Santa Ana where actually a councilman was woken up in the middle of the night. He heard a lot of Disney music being played, and he sees a bunch of police cars across the street. So he goes down, talks to them, and he asks them, why are they playing Disney music? And they point to an individual who had a bunch of cameras and their cell phone out in the corner, and they say, well, if that person tries to post anything that they're recording, they'll get, quote, a copyright infringement, and it'll get taken down and removed. And so that is the purpose of this bill, is to prevent that purposeful use and misuse, I should say, of copyright law at the hands of peace officers. This becomes really sticky because you're kind of at the mercy of the technology a lot of these social media sites use. Many of you may be familiar, like if you've been somewhere and you're like, oh, what's that song? You pull out your phone, like Siri or an app, and it says, hey, tell me what song this is. And it tells you this is the artist, the album, etc. Well, these social media sites use these same technologies in order to scrub their websites. And if they detect that there is a post that has unauthorized copyrighted music on it, then it will remove that post. And therefore, that's where the censorship comes into play. So this bill now, I believe everyone should have received the conceptual amendment. We've been talking to stakeholders with, which would change the language somewhat so that this would just require the law enforcement agencies in Nevada to adopt a written policy that would present this specific narrow misconduct by police officers. So that's the gist of Section 2.
So with that, we will open ourselves up for questions.
All right, committee members, any questions for Senator Neal or Mr. Green? Yeah, okay. Senator Hansen.
Actually, I'm very, thank you, Madam Vice Chair. I'm very fascinated that you brought up the copyright thing. I've never heard anything like that before. When I read the bill, I go, man, I'm missing something somewhere. I guess the question is on the copyright side of it. I've noticed this isn't directly to do with the bill, but we can't post simple things on Nellis anymore, even if they're government agency things, because there's alleged copyright things. Since I got an attorney in that field, I'm just kind of curious. We used to do it all the time. Now, is there some new expansion of copyright stuff to where somebody literally can play music and if I record it, I can be accused of a copyright violation?
Caleb Green for the record. Great question, Senator. So I understand your question is there been an expansion of copyright law that as it pertains to playing musical works and someone being liable for copyright infringement? I wouldn't say there's been an expansion, but there has been a targeted use of it by certain peace officers. If I can kind of explain, again, the way that it works is, particularly when you're dealing with social media sites, at the beginning of the turn of the century, the end of 1999, beginning of 2000, the year 2000, we had the dot-com boom. This made it very difficult for a lot of what we call internet service providers. So your Googles, any place where users could upload content. Think today like your Twitter or your Facebook, where you yourself can upload content. It became an issue because now you have, say, Facebook, and now they're hosting, let's say someone uploads material that is infringing. Who do you go after? Do you go after the user? Do you go after the internet service provider? Do you go after both? So the Congress came up with the DMCA, the Digital Millennium Copyright Act, and that gave a safe harbor for these, let's just use social media sites, that if they act swiftly and when there is infringing content on their platform, that they will not be held contributory liable for the infringing material that was posted by their user. So that is where kind of this loophole comes into play. So it wouldn't necessarily be, I wouldn't characterize it as an expansion, but now there is, copyright can be a very complex area, and especially when certain websites and internet service providers are trying to take steps to avoid infringing materials from being on their websites, and they take these proactive steps. Sometimes you can get you get loopholes like this where if someone is posts something with copyrighted materials in it and they do not have authorization, it will be automatically removed
from those particular internet service providers or social media sites.
Sounds like you have a very, what would the word be? Remunerative, a very financially successful future. Sounds like it's a very complicated field of law. No, I'm just kind of intrigued by the whole idea. I've never even heard of such a thing before, so thank you for the explanation.
Additional questions? We'll go to Senator Krasner and then Senator Stone.
Thank you, Vice Chair. Just a quick question. Thank you for your presentation. Is this a type of copyright infringement going on here in Nevada?
Caleb Green for the record. To my knowledge, I haven't uncovered any reported instances, but I think one thing that's important to know is that just because there have many reported instances doesn't mean it doesn't necessarily happen. And one thing to consider is, so when you're dealing with specifically, I'm focusing on social media sites because that's where we see this largely be shared, certain recordings of police officers. They have their own internal mechanisms to stop repeat infringers. Some websites have, like, let's say, a 3-strike rule. Others have a little bit more looser of a policy, others more strict. So you may be in a situation where someone may have a recording, for example, and they may already have some strikes against them, and they don't want to upload this because maybe this gets my account banned, maybe it doesn't. The other thing is that sometimes the automated process, these things just get removed automatically, and regular citizens, unless they have an intellectual property attorney like myself to help them, they don't have the means or the know-how to protest that and get it put back up. So to answer your question, I haven't uncovered any, but there is a chilling effect with this particular practice that is certainly relevant.
Senator Stone, go ahead, please.
Thank you, Madam Vice Chair. Thank you for the presentation, Senator Neal. Can I just see that picture, that symbol again? I wasn't able to see it from this angle here. So, and is that going to be somehow displayed in the bill as, I would probably call it a Nevada caduceus. That's exactly what I think it is. So, and I appreciate the creativeness. I really like it a lot. Now, if I can just get to a couple of questions. Section 4, 2B, you list a lot of medical conditions that I think are great. That only one I'd like you to maybe consider adding, maybe under anticoagulants, is a condition of hemophilia, right? So these are people that have bleeding disorders that somebody would probably want to know about, especially if they're in some type of a traumatic accident or getting scraped or something. And then also, I assume that there's already some type of HIPAA compliance at the DMV with respect to the dissemination of medical information that is strictly governed as its distribution.
So Senator Dina Neal for the record, so that's why it's voluntary, right? So a person would have to, I can't mandate that someone disclose a medical condition to the DMV. They would have to voluntarily give it, and it'd be the same. So the 2007 and 2009 law, it actually exists under the NAC 483.077, where I built from. I guess I assumed, number one, it was voluntary then, that the HIPAA and the issue was dealt with through that voluntariness. So that is saying that the person is willingly allowing that information, or at least the code, to exist in the system with the symbol on their license because they will want to share it.
No, I don't disagree. I just worry about any dissemination, whether it's given voluntarily or not. It's still personal information that I think HIPAA would cover. And I would assume that the DMV's got this covered, but I just throw it out there for your attention.
No, Senator Dina Neal for the record. I think that's a good question. I don't know if DMV is here, being that the law was in place in 2007, whether or not they encountered any kind of HIPAA violation under the code that was passed. Because it's current law, I'm just modernizing, changing method, and adding more disease.
Yes, and I appreciate that. I just want to just make sure we're protected as a state. I really appreciate your presentation, and I love the caduceus.
Thanks.
Additional questions from committee member Senator Ornschall.
Thank you, Vice Chair Harris, and thanks for your indulgence. More of a comment. I really appreciate the bill. Thank you for presenting this, and glad you're building on former Assemblyman Senator Sagerblum's work here, but I think you're taking it where it needs to be, and thank you so much for your hard work on this bill.
Any other questions? Okay, we'll go ahead and open up testimony for Senate Bill 362. All those here in Carson City in support, please take the seats. And Ms. Roth, you can begin when you're ready.
Thank you, Vice Chair, members of the committee, Erica Roth, on behalf of both the Washoe and Clark County Public Defender's Office. I guess my testimony could be on itself that I'm up here with the police, but I'll say a few more words. Brian Stevenson once wrote that we don't need police officers who see themselves as warriors. We need police officers who see themselves as guardians and part of the community. We can accomplish this when we provide them with the tools and information that they need to keep our communities and themselves safe. We expect a lot from our officers, and we don't always give them those tools, but providing them with information about the people that they will be coming in contact with, it makes us all safer. I'm sure that they can attest to the fact that they're trained that, for example, a traffic stop is the most dangerous situation that they can find themselves with. And if you're told that over and over again, you're going to approach a traffic stop with danger in your mind, right? And so if we can, in those situations, give them additional information about the people that they're interacting with, it's going to make the community safer. And to make the community safer, we also need to hold them accountable and ensure that there's transparency in that policing, and by ensuring that they are not uploading videos or playing music that would preclude those videos from being uploaded, that there is transparency. I also want to note that it's my understanding that that has not occurred in the state of Nevada, and so I think it's an opportunity to say that as Nevadans, this state is a role model, and that our police are a role model in this respect, and we can say that it won't happen here moving forward. Thank you.
Good afternoon, members of the committee. Jason Walker, Washoe County Sheriff's Office. I am in support of SB 362 as amended. Thank you for the time this afternoon, Senator Neal and Mr. Green. I am proud to say we already have policies in place that closely mirror this bill regarding the care and custody of arrestees, starting with our use of force policy, working into our handcuffing and restraints policy, and when those are in use, we also have medical considerations while those restraints are in place. Followed up with our duty to intercede policy, which I'll read for the record. Any deputy present and observing another deputy using force that is clearly beyond that which is objectively reasonable shall intercede to prevent the use of unreasonable force. We practice that and preach that every day. The medical symbol portion of this bill is simply another tool to help us bridge any gaps in communication or to assist us in our duties. And again, testifying in support of Senate Bill 362.
Thank you, Vice Chair, members of the committee. For the record, Mike Cathcart, representing the City of Henderson. We'd first like to thank Senator Neal and Mr. Green for their time on hearing our concerns with Section 2 and offering the amended language that we support. We now support the entire bill. Specifically, we support Section 1, rendering medical aid as common practice and operating policy of the Henderson Police Department. The department's current policies on transporting arrestees, tactical incident response, and use of force all have medical aid components. Thank you for your time, and the City of Henderson is supportive of SB 362.
Good afternoon, Vice Chair Harris and the Senate Committee on Judiciary. My name is Chris Reese, R-I-E-S, and I represent the Las Vegas Metropolitan Police Department. We are in support of SB 362. Just for clarification, LVMPD's use of force policy can be viewed online on our department's website, as well as our 5-year use of force report. Our policy is clear on summoning medical attention whenever an officer applies a use of force to include, quote, a use of force option upon a subject that results in either observable signs or complaints of injury or difficult breathing, end quote. We also recognize the importance of continuing to monitor the subject and update medical personnel with any changes of the subject's condition. Persons that have a prolonged struggle with an officer are at an increased risk of medical distress, and we will proactively request medical attention even if the person does not ask for it or advise us of their difficulty breathing. Even more, we will place the subject in a recovery or seated position once it is safe to do so. We have worked with Senator Neal and Mr. Green on a proposed conceptual amendment requiring each agency to develop a policy preventing misuse of copyright laws to prevent videos of officer being shared on the internet. We appreciate Senator Neal and Mr. Green's willingness to include us in their conversations on SB 362 or in support of the bill. Thank you.
Good afternoon, Vice Chair Harris, members of the committee. Greg Herrera for the record, Herrera, representing Nevada Sheriffs and Chiefs Association. We are in support of SB 362 and appreciate Senator Neal in bringing this bill forward. I think having any medical indication readily available to officers, providing quick information to move forward as quickly as possible of any underlying medical conditions is absolute benefit, and we're in strong support. I am proud to talk about real quickly the advancement of medical assistance as far as law enforcement across Nevada. You'll see law enforcement across Nevada now armed with naloxone kits, tourniquets, AEDs, and equipment that renders aid in a quick fashion. Also, as far as the copyright violations, in full disclosure, in the early 1990s, in an effort to show inmates movies and popcorn night, the Washington County Sheriff's Office and former Deputy Herrera violated some copyright stuff as far as Blockbuster and that stuff. We didn't have permission, so I could have used Mr. Green's services back then. That was all in goodwill. The examples that Mr. Green provided today are not, and we're full support of rectifying that with policies, and I'd be honored to assist in that. Thank you.
Okay, not seeing anyone else in Carson City. I don't see anyone in Las Vegas either. BPS, can you please check the phones for testimony in support of Senate Bill 362?
If you would like to testify in support of SB 362, please press star 9 to take your place in the queue.
Anne Marie Grant, ANNCMARIEGRANT. I'm calling in support of SB 362. My brother Thomas Purdy was hogtied and asphyxiated to death by Reno Police and Washoe County Sheriff's Office. I am unimaginably grateful to the sponsors. I'd like to remind everybody that policy is not law. Had this bill been codified into law in 2015, my brother would hopefully be alive today, as sadly it certainly wasn't the policy or practice of the Washoe County Sheriff's Office to get medical attention for someone who indicates they can't breathe. I say this because Thomas was one of 3 men asphyxiated by Washoe deputies within a year, and all of them told them they could not breathe, and none of the deputies themselves attempted to render medical aid to my brother. Once his heart stopped, when 4 deputies got on his back, neck, and legs while he was still hogtied, he pleaded and begged for decency from the deputies and for an ambulance and told them he could not breathe. They thought it was objectionably reasonable to smother my brother, and not one of the multiple deputies intervened. They had all the equipment to save my brother. They willfully chose not to. I remember so vividly walking into the ICU to see my big brother, my best friend, laying lifeless in a hospital bed, connected to all kinds of machines, wires, tubes down his throat, keeping his heart pumping. I remember becoming physically ill at the condition my brother was in at the hands of law enforcement. I remember the violent retching in my stomach as I became physically sick. I remember seeing my dad cry and, worst of all, question what he had done wrong for this to happen to my brother, when in actuality those who claimed to protect us were to blame. The guilt and grief each and every one in my family carries because we could not save Thomas from law enforcement haunts us daily. This bill will save lives if police choose to follow it. And as far as copyright issues, I can attest I come to Nevada every summer, and I go to the Washoe County Jail. And if anybody would like proof that the officers are using copyrighted material, I can provide it because I filmed them. And they walked by, and he blared his radio from his phone every time he did it with music because he knew that was copyrighted material. Please support this bill. It will save lives if police choose to follow it. Thank you.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. We strongly support this bill. And we would like to echo the comments made by Miss Anne Marie Grant. I have seen that video of how her brother struggled and pleading for his life, for help, calling out for his dad to help him, that they're killing him, telling them that he had a lung condition, he had lung surgery, things such as that. It is horrific video, and it's a must-see for all of you to look at, to make these changes. This man should have been given proper medical care right then and there on the spot, not his body tossed into a cell and left there, and then making comments about, well, he's quiet now. He was nearly brain dead, and he became brain dead. This needs to stop. The officers need to be held accountable, and this bill can and will help future families, we believe, from going through what Miss Purdy, Miss Anne Marie Grant and her family, the Purdys, have gone through. Thank you.
Hi, Katrina Ivanov, IVANOFF, aka Mrs. Fixit. I support this bill mainly because the officers are supporting this bill, and that tells me it's going to make their job easier. Other than that, I'm not very familiar with the bill. It's the first time I'm hearing of it. So if I find something that I don't like in it, I reserve the right to express it at that point. But just solely on the officer support and the two ladies before me, I support this bill.
There are no remaining callers to testify in support.
Okay, thank you. We'll come back here to Carson City. Anyone want to testify in opposition to Senate Bill 362?
I'm in opposition. I might be a little bit confused, though. I just, from what I can see, it just kind of furthers and extends itself.
Ma'am,
over
can
into,
you say your name for the record,
Casey
please?
Rogers, for
Thank
the
you.
record. I just kind of feel like this kind of extends the tracking stuff that everybody's trying to do right now. I just, I feel like it's a safety thing, but if an officer is going to get in a squabble with somebody, I don't think it's going to come down to whether they have a medical condition or not. It's just going to be a squabble regardless. So this kind of like keeps cutting at, I don't know, personal rights, liberties. I don't know. Like I said, I could be confused, but right now as it stands, I have to say I'm in opposition just because of our current climate. Thanks.
Anyone else for opposition here in Carson City? Okay, still not seeing anyone in Las Vegas. BPS, can we check the phones for opposition testimony, please?
If you'd like to testify in opposition to SB 362, please press star 9 to take your place in the queue. We have no callers to testify in opposition.
Okay, neutral testimony. Anyone in Carson City for neutral? No one still in Las Vegas. BPS, you're up.
If you would like to testify in the neutral position for SB 362, please press star 9 to take your place in the queue. We have no callers to testify in neutral.
Okay, Senator Neal, would you like to make any closing comments?
Thank you, Madam Vice Chair, for the Senate Judiciary, number one, hearing this bill on a late afternoon. The bill is voluntary. I do put in the provision in the bill to make sure that DMV lets people know that that option actually exists, so that folks can take advantage of it. I think it will be, I think it will enhance safety on both sides. It will help to provide additional discernment when you have a stop. And so I will leave it there, and I'll let Attorney Green say something.
Caleb Green for the record. Thank you, Senator Neal and Vice Chair Harris and the Judiciary Committee. Thank you again for the opportunity to present this bill for you all today. I want to also commend and thank various stakeholders, specifically the various law enforcement agencies, Henderson, Metro, and Washoe, that met with us as well. I think this bill is a great way to tackle a very complex issue and loophole that is very fleeting. At the same time, it is a wonderful opportunity for Nevada to be a leader on policing and what policing should look like. I very much hope it's never been the case, any of this use of copyright weaponization by peace officers. And I think our police officers should be commended for that. And I think this is a great opportunity to send a message to the rest of the nation on what policing should look like. So thank you all for your time.
Okay. With that, we will go ahead and close the hearing on Senate Bill 362 and open the hearing on Senate Bill 395. And welcome back, Senator Neal.
Thank you, Madam Vice Chair. Hopefully everybody has the amendment. There are words missing. I want to talk about that first, and sub 2 in the amendment. It should say 1,000 housing units, and it doesn't reference what I'm talking about. So Senator Dina Neal here to present SB 395. So over the summer, I had a series of conversations with realtors, the developers, and Secretary of State Fraud and Securities Division. And because of that conversation with the Securities Division, that's how I landed on this bill. So I want to do a couple of public policy statements before I get into what this bill is doing. But ultimately, when you read it and you read the amendment, you see that I'm limiting investment, and that I'm limiting corporate investment within the state of Nevada. Where does that power come from? How am I able to even present this bill in the committee? So in order to enact legislation, number one, we have to be clear on what it is that the state is actually trying to examine and deal with. And in this case, the central public purpose of this bill is to allow families to purchase homes without having to bid against investors. So the idea is to limit the amount of transactions that happen within a year, to free up property so that individuals can actually go and purchase property. We currently know that we're in a housing crisis. The Supreme Court's modern understanding under the Equal Protection Clause basically says that a state's economic legislation is constitutional as long as it is rationally related to a legitimate state purpose. That state purpose is the housing crisis. In addition, because I'm talking to a bunch of lawyers, that the Commerce Clause is also typically invoked and asked, and people wonder, okay, well, where is the Commerce Clause in saying that there's an undue burden on interstate commerce related to the investor that wants to come in? So under the police powers, it has been well understood that the state's police powers are not restricted by the Commerce Clause when it is tied to a legitimate public policy purpose in which you are trying to protect your citizens from a particular activity that is considered harmful or is enhanced into the level of what we consider a crisis. Have we encountered this kind of policy before? Yes. 2015, 2013, I distinctly remember sitting in government affairs on the assembly side where we had a conversation about construction. We had a conversation when we were in the middle of the Great Recession talking about the powers of the state in order to create more jobs for Nevada citizens. And we literally put a 50%, I would say a 50% or 50-50 limit on 50% of the jobs had to go to Nevada citizens, because the goal in which we were trying to achieve was to make sure that our Nevada citizens that were out of work during the Great Recession would be allowed to work. The questions that came up was whether or not that violated the Privileges and Immunities Clause. The answer was no, because of the citizens that we were attempting to protect, not long term, right, but for a short term period of time until we could right size up our own citizens in Nevada. So when we look at the 14th Amendment and we talk about what's the inherent police powers, number one, it's broad. Number two, rational basis is probably one of the lower standards that you must meet in order to determine whether or not there's a due process or a 14th Amendment issue. The other thing that's invoked from this policy is whether or not, what is the state's power under the Fifth Amendment? And so the Fifth Amendment comes into play because in a wide variety of contexts, the government may execute laws, programs that adversely affect recognized economic values without the action actually constituting a taking. And in those instances, that's where we get into those issues of zoning laws, we get into the issues of the health, safety, morals, or general welfare that would be promoted by prohibiting a particular or contemplated use of land. The Supreme Court has upheld land use regulations that destroyed or adversely affected real property interests. In many instances, those restrictions that served a substantial public policy purpose have been upheld. And I say this to you because I wanted to at least set the framework and the foundation of why I was bringing a bill that would limit aggregate purchases over the year, and why the public policy purpose of the issue of the housing crisis then gives the power to the state legislature to then weigh into this area in order to protect its citizens. So with that, I'll talk about the bill. So you have a, I won't say it's simple. I'm sure it creates all kinds of interesting conversation, because I did watch the Senate Commerce hearing this morning, which is very special. And so I'm not doing rent control. But what I am doing, when we had this conversation, we talked about hedge fund investors that were playing in the market, and how those hedge fund investors were coming in and buying up property, siphoning up property, and then driving up prices that were preventing our own citizens from coming in and literally in a bidding war with a corporate investor and not being able to move on a property because they didn't have cash, because they had an FHA loan, because they had a conventional loan, and they weren't able to compete with the investor that was on the other side of the deal. So we had homeowners or potential homeowners, Nevada citizens, who were seeking to find property and could not because it was well priced out of their price range. We know that's happening in Reno. We know that's happening in Washoe. We certainly know that's happening in Clark. I know for a fact in my own, my dad's neighborhood, 1965 home, $368,000, but yet when it was purchased, it was $65,000. But the going market has driven that price up. We know that in the past, that was similar in the Great Recession. In 2010, 2011, 2009, that spiral of the investors coming into the market was created because we had these massive foreclosures, these balloon payments, these home payments that people actually could not manage. I also believe that the environment during pre-COVID there was investors playing in the market, but I think it went on steroids when we entered into COVID. And there was an increased behavior around investors coming in and siphoning up the new construction that was on the market. So the bill in Section 1, and I'm going to speak to both the amendment, it talks about the Securities Division maintaining a registry. So I started thinking, okay, how do I even get into this? Who do we know is even playing in the state of Nevada? First thing was, let's get a registry of the corporations, limited liability companies who own real property, excluding family trusts, exempting the Nevada housing. And initially, when I had this bill, it would have only focused on the hedge fund investors. But when I talked to the Securities Division at the Secretary of State, when they looked at who was playing, potentially doing some fraudulent activity, they wanted to keep the net a little bit more broad in order to have the registry. So in sub 2, it talks about the corporation or limited liability and why they must register before purchasing. Why we wanted to do that is because we want to know who is playing in the market. In order to do an aggregate or limiting policy, which is an economic regulation, you need to actually know who's purchasing, how many folks have engaged, and so there has to be a place. So it made sense for it to happen right at the Secretary of State's level because they were already doing similar work. So in sub 3, it lists a charge of a fee, a nominal fee to do the registration to cover the administrative cost of how this would work. So in section 1, I then add in the amendment the protection against the aggregate purchases and then limiting the purchases to $1,000 a year for the housing units. And I know the question's going to come up, how'd you come up with this number? There is no case law that gives you a number. There are several states that have engaged in some restriction on corporate housing, whether or not it was a foreign residency tax, whether or not it was doing some form of, barriers for dwelling units. I looked at the gamut of where everyone was, and there was no one who was doing a particular aggregate policy. So then I started to look, well, how do I legally protect the policy? How do I constitutionally protect the policy to make sure that I'm in the right framework and I can do this? And then that's why I had those provisions around due process, Fifth Amendment, takings, and the 14th Amendment. So I was also asked while I was looking at this policy from stakeholders who were outside of the conversation that I was having with the realtors and Securities Division and the Real Estate Division. They were like, well, why don't you do a foreign investor tax? Other people have done that. They charge the investor money and they make a foreign investor tax that they move in. I was like, no. So I'm not interested in doing that. As much as I'm a revenue chair, I'm not interested in engaging in that policy. So the bill then continues to talk about what then happens after they register, they purchase, then they go and record. So that's the cleanup language where in, I believe, amending section 2, 7A, line 22, the word says county clerk and it should say county recorder, because we also had a conversation with the county recorder saying, all right, if we bring this bill, a couple of things we need to do. We need to change the deed, because right now a deed does not allow you to check a box that says institutional investor at all. Number 2, we need to make sure that the recording that happens at the Secretary of State Securities Division matches when you go down to record. In addition, we needed to make sure that there was some kind of documentation that represents the form that would come from the Secretary of State's office when they go and record the deed. We know that majority of the transactions are not a loan transaction, right? They're cash transactions. So we try to make sure that the filing match, because there were a lot of questions from the county clerk, county recorder saying, well, what if their name is different? And I was like, well, the whole point is legally, we're making sure that the names match. You can't come in and say, well, subsidiary A, subsidiary B is doing this. It all needs to match the documentation. And so it also acts as a secondary check because the then Securities Division is then the entity who is going to operate on the aggregate limit. Why did we do it that way? Because it seemed to be simpler is better versus having a 3-layer part where initially I had looked at examining bringing in the Clark County business license, so then the Clark County business license will be a third check to make sure that the corporate investor would then be, we would allow for some other check within the system to see if their names were matching, to see if everything was in alignment. But we decided to place everything with the Securities Division at the Secretary of State's office. So I know a question is going to come up. What is this magical form? We also thought about that. So there is, if you've ever been on the securities page of the Secretary of State's Division, there's a form, an N9 form, that we felt met the qualifications of something that we could amend and change to meet the needs of this bill because it already dealt with a certain type of investor or hedge fund. And so that's what we looked at. Like I got into deep, super details on like, okay, how would this work in real life? What does this look like? And if you guys have any questions related to the hedge fund piece and why we didn't add in C6, C7, C5s that are in the SEC, because that's initially the narrow place that I was going to go, which was only going after those particular entities that had an SEC filing. It was because of what was going on at the Securities Division, which they are better able to explain that piece. I believe the deputy director is here in neutral to help and answer and fill those questions. But with that, you have the amendment, you have the bill, and so the bill is only a couple of pages, and so I will open myself up for questions.
Thank you for that, Senator Neal. I have a question about the 1,000 units that you mentioned in the beginning. Am I understanding your intention is this only to apply to institutional investors who own 1,000 or more units?
Senator Dina Neal, for the record, in the aggregate, it would limit the purchases over a 12-month period.
Got it. Okay. So it's not about who this would apply to, it's about how many they'd be able to purchase in 1 year.
Correct. Because Senator Dina Neal, for the record, because the idea was if we're in the middle of a housing crisis and folks are looking to try to figure out how to purchase their first home, right? So there's data that literally spells out that individuals, we have a mixed market, right? We have large investors, then we have small investors who make up the market. And so I wanted to make sure that's why I exclude family trust, because number one, there are a couple of instances that happen. Number one, you can own a second property, you could potentially acquire a second property because you have created a trust, because you want to protect your property, right? There are other instances where, as a corporate entity, you're literally buying swaths. So if you guys look at that PowerPoint, it's not a PowerPoint, but it was a presentation from, Sean McCoy, and this is his, and I want to be absolutely clear, although he has a PhD, although he works for Lead Center of Real Estate at UNLV, this is his personal work product. This is not the work product of UNLV. And so we had a conversation with him over the summer so we could get an idea of who's actually collecting this information on what's happening. And so this data that he presented spells out how he was able to go into the assessor records and then figure out how he was mining data to figure out how many investors were in the market. So he mined for trusts, he mined for LLCs, and then he looked at the fact that there were companies, if a company had purchased 100 homes or more in their registered name, he also looked at how many times their name popped up. And so you would have groupings where their names would pop up in groups of 10. And so that is where I use this information to try to help me figure out what's the number I land on, right? If I say 100, then how is that a reasonable economic regulation? If I say 500, am I still getting into, is that a reasonable economic regulation for the purposes of saying that the state wants to engage in limiting behavior under its police powers? So I went with 1,000. I searched I mean, when I tell you I pulled out my old con law book, I pulled out the new one that I purchased last year. And I was like, well, maybe I'm missing something. And let me just reread and re-educate myself on constitutional law so I can fully understand the wealth and the breadth of case law that maybe I wasn't in school for. And so I didn't find any cases. Everyone is doing something else, right, other than what I'm proposing.
Congratulations, you've successfully scared off all the rest of the Democrats on the committee. I'm kidding. We've got bill presentations and other things going on, as I'm sure you know. Senator Hansen.
Thanks, Madam Vice Chair. Actually, I'm just so impressed by your presentation. Seriously, the amount of homework you've done on this is amazing. And the problem, you and I briefly discussed it on the floor, it is a legitimate major problem. Whether or not this is the solution or not, I don't know. But the very fact that you're trying to at least come up with some skeleton form of at the very least, finding the data. Because to me, what I'm fascinated by is I've never heard of this before, of potentially foreign investors coming in and buying up huge blocks. The numbers, according to Mr. McCoy, is about 10% of the market, which is huge. So out of curiosity, my fear, frankly, is China. Do you know is the money coming from, when I say foreign investors, we don't know. Is that what you're shaking your head? Because I remember very distinctly in the 80s when there was a huge fear. We had Japan had a huge trade surplus, and they're literally buying up the island of Hawaii. And I'm just kind of wondering if we're seeing a similar circumstance now.
Senator Dean and Neal, for the record, I think had I kept the SEC language in my original draft, I mean, because typically when you do an SEC filing, you have to give some additional information. Number one, where are you from? Where is your corporation principally established? If you're out of the country, what are you engaging in? And so they're still going to be captured under this bill. I just think that we're going to have to wait and see if this bill was to pass after, the signal is sent that you need to register, then we're going to find out who's playing in the state. And then, and I trust the securities division because they're already engaged in who's fraudulently playing. And this will just allow that data to expand for us to have more knowledge on what exactly is happening, who is playing, right? And then maybe further down the line to examine how to deal with those entities.
Well, I'll be interested to see how that whole thing plays out, because I mean, there's a lot of economic questions in that whole thing too. For example, if you're selling your home, obviously you want to get the maximum dollar amount, and if some foreign corporation or whatever, offers you, like the example you gave, your dad's house, it was $65,000 when it was purchased back in the 80s or whenever, now $400,000 or even more. And the normal market price would be $300,000, $400,000, and somebody comes in and offers you $550,000. It's kind of a tempting thing to say, well, even though they're a foreign corporation, hey, I'll take the extra, $50,000 or whatever. So I don't know. It's kind of an interesting dilemma because, on one hand, I see that where you're going with it, and I think it's a great idea because I've watched out with my own kids trying to buy homes in the Reno Sparks market, and the market has inflated so much beyond what just normal inflation adjustments would create. So yeah, I'm interested to see where this will all go. I mean, in my mind, this is a skeleton form.
It is.
Just trying to get a grasp on what the problem potentially could be, then try to develop solutions for, I guess you'd say, excessive levels of foreign investment that's causing the prices to go so high, local people just can't afford it anymore.
Senator Dean and Neal, for the record, yes, some people are probably going to say it's not a baby step because you're limiting aggregate purchases. But what I've seen from even medical residents, you can't save $15,000 cash and you can't get into a home. I'm meeting young people who make $78,000 and they cannot find a house. They don't have any children. They cannot bid. They don't have the money. The market is so out of their price range, right? Who wants to pay $3,000 a month for your first home? Nobody. And it's unsustainable, actually. And so although, the flurry has kind of simmered, the idea was to put something in place for the next wave, right? this bill missed the wave. If I'd had this conversation in 21, it probably would have been in the middle of the wave. But I want to make sure that what happened in 2011, what happened in 2019, 2020, 21, 22 does not happen in the future. And we have some kind of protection there to prevent this swaths of property just coming off the market, right? And this competition with a cash corporate hedge fund buyer you cannot compete with. And I certainly know that our single families cannot compete with them. So this is my way of trying to do protectionism for our own people.
Well, thank you. I'm not a free trader, by the way, so protectionism is not a bad word to me. Thank you.
Additional questions from committee members? Okay. We'll go ahead and open it up for testimony in support of Senate Bill 395. No one in Carson, no one in Las Vegas. BPS, can you check the phone, please?
If you would like to testify in support of SB 395, please press star 9 to take your place in the queue. We have no callers in support.
Anyone here in, thank you, BPS. Anyone here in Carson City who would like to testify in opposition to Senate Bill 395?
Thank you, Madam Chair. Josh Hicks with McDonald Carano, representing the Nevada Home Builders Association, the Southern Nevada Home Builders Association, and the Builders Association of Northern Nevada. I want to thank Senator Neal, first of all. She included us in the working groups, and we very much appreciate that, very much appreciate what the senator's trying to do. I think that a lot of this bill is really targeted at the already built homes that are going for sale as opposed to the newly built homes. But I did just have a couple comments that I wanted to put on the record just because this is working through the amendment process, and we just really have a conceptual amendment at this time. So the comments, I'll mention on the as drafted version of the bill, section 1 of that's the registry section. And the people who would be on the registry are any kind of corporate entity that purchases or owns residential real property. That doesn't distinguish between property with a home on it or raw land. So I would just suggest that maybe a clarification there might be to exclude things that are just raw land, zoned residential. Those are often owned by home builders, for example, before something's built on it. And that's all public record. It's on the assessor's webpage. With respect to the conceptual amendment, and just had a chance to look at this today, but there was the amendment to section 1 that would exclude family trusts. I'd suggest that perhaps intercompany or to affiliate transfers might be appropriate there too. Again, home builders sometimes transfer things around before homes are actually sold to an end user, if projects are done in phases or things like that. So that would probably be an appropriate exclusion there as well. With respect to the 1,000 a year limitation in homes, or whatever the number ends up being, I think the concern there is to the extent that the bill applies to new build construction, how a seller or how a home builder makes sure they can comply with that, how it's enforced. So making sure that they're not inadvertently violating whatever that number is, I think would be very important to the members of the association. 2A on the conceptual amendment talks about an exclusion for a sell date being the same as the construction date. I'm not sure what the construction date is, but to the extent that that exclusion were to be for new build construction, which we'd certainly support, I think that would take care of a lot of the home builders' concerns in this bill. So that's just what we wanted to say for the record. We're very much looking forward to the amendment and to continuing to work with Senator Neal. And again, we thank her for including us throughout this whole process. Thank you.
All right, not seeing anyone else here in Carson City. Is there anyone in Las Vegas? Not seeing anyone. BPS, can we check the phones for opposition testimony to Senate Bill 395, please?
If you'd like to testify in opposition, please press star 9 to take your place in the queue.
Hi, Katrin Ivanov, Ivanoff, aka Mrs. Fix-It. First, I want to start that I'm very pleasantly surprised to hear Senator Dean bringing this bill, because all the bills I hear was her trying to get more money out of Nevadans. So I am very pleasantly surprised. I like the premise of the bill. I'm not sure if 1,000 units for people that are coming to buy and compete with homeowners is a small number. As a person that can only afford one house, I think that 1,000 houses per company, and when you have so many companies coming even from out of the country to invest in Vegas, I think this number is a little bit high. However, I have nothing to base it on, just my personal opinion. Other than that, I love the premise of the bill, and I wish they were taxing those companies more, because she likes taking a lot of taxes, but from the people. So how about tax the companies? Just add an amendment. If you're an investor from out of state, you have to pay more taxes to our state. Just an idea. Thank you. I do like the idea, though. Thank you. Bye.
Hello? Can you hear me?
We can. Go ahead.
Hello? Oh, okay. I tried to call earlier on agreeing with it. I wasn't quite sure. I guess I'm neutral more than anything. My name is Susan Prophet.
Okay, ma'am, you're going to have to wait till we get to neutral
with-
testimony then, please.
All right, I will wait. How do I do that?
You just hang on the line, and BPS will cue you when it's time.
All right.
Okay, anyone here in Carson City for neutral test? Oh, I'm sorry, BPS, any additional callers for opposition on the phone?
No, Chair.
Okay, thank you. Anyone here in Carson City to testify in the neutral position? Welcome, Deputy Secretary.
Thank you,
Lovely
ma'am.
color shirt you're wearing today.
Thank you very much, Madam Vice Chair. Gabriel DeCara, for the record. I serve as the Chief Deputy Secretary of State, and I am wearing Old Navy at present. The Securities Division is one of several divisions within our office. It oversees and administers the provisions of the Nevada Securities Act found in NRS 90. The Securities Division is responsible for registering and licensing all investment products sold in Nevada and the people that sell or recommend them, as well as enforcing the anti-fraud provisions found in NRS 90. The Securities Division has a criminal and civil civil enforcement divisions. The Nevada Secretary of State offers public comment in the neutral position, but we are here to help and stand ready to assist with implementation of SB 395 if passed. Our office is devoted to investing in technology to provide overall better access to data for the state and its residents, and we will do our best to ensure that SB 395 is implemented quickly and efficiently for use by all. I would like to thank Senator Neal for reaching out to our office and working with us on this bill, and personally for her dedication to helping solve the housing crisis in our state. Thank you.
All right. Also not seeing anyone in Las Vegas for neutral testimony. BPS, I know we have at least one caller who'd like to testify in the neutral. Please queue him up now.
If you'd like to testify in neutral for SB 395, please press star 9 to take your place in the queue.
Wiz Rizard, W-I-Z-R-O-U-Z-A-R-D, Deputy State Director with Americans for Prosperity here in Nevada. In terms of SB 395, we are currently neutral, but I do want to acknowledge and give much support to the bill sponsor for bringing to light an issue. It is something that is new. We are currently looking at it, but we did want to acknowledge her effort and bring into light this issue and trying to look for better solutions. The overall long-term concern is just the whole thing of how do you boil a frog? You have to slowly cook it. So when we're talking about legislation, how do you disrupt the market? Sometimes that slow cook ends up hurting the individuals we seek to help. And we believe that property rights extends to those accessing economic opportunity. So for those who are selling their property, we want to make sure that they're able to actually access the market and get as much value as they can for the home that they're wanting to sell. And so that's our concern. But overall, we do want to say thank you to the bill sponsor for bringing this, and we are looking at this a little bit more extensively. Thank you.
Hello, my name is Susan Profit, and I'm the Vice President of the Nevada Republican Club. And I actually own some property in Florida, so I have some experience with this. At first, I was going to, and I did, testify. I mean, I sent in an opposition, but I will retract that because I'm very impressed with Dina, and your presentation was excellent, and you obviously know what you're talking about, and I've experienced some of what you're talking about. The properties that I have in Florida, I'm constantly getting calls from people with a Chinese accent, and we really do need to protect our citizens here. I see a need. The first thing I was concerned about, though, was the added expense of adding, creating a new registry, within the securities division, and the costs that would be involved in that. So here's what I'm going to say. I really like your ideas. I think we need something like this. I would like to know how Senator Stone feels about this, because I'm considering the fiscal responsibility aspects of it as well as the security aspects of it, because we don't want it to become something that is heavily burdensome on the small investors like myself. I mean, anyone who has 5 to 25 homes this could really be a problem for some of them, and I'm wondering how you're going to accommodate them. So thank you for addressing this. It's wonderful. You did an excellent job.
There are no further calls to testify in neutral.
All right. Senator Neal, I don't know if you want to come up and try and top that. All right. Well, then we'll go ahead and close out the hearing on Senate Bill 395 and move on to public comment. Anyone here in Carson City for public comment? Not seeing any. Also no one in Las Vegas. BPS, can we please check the phones for public comment?
If you would like to provide public comment, please press *9 to take your place in the queue. We have no callers providing public comment at this time.
Okay, with that, ladies and gentlemen, we are adjourned. Everybody have a great weekend. Happy Easter.